Any mention?
Yeah, please, Lordship. I beg to mention item number 7 and 8, Lordship.
Number
7 and 8.
it's for hearing.
Is for hearing, Lordship. The matter may come up after 2 weeks, Lordship.
Why? Not
Lordship, some preparation is required.
yes, no objection.
No objection.
Yes, 2 weeks.
Okay. Deploy.
Item number 1.
The 3 and 4 connected. Mr. Saraf is leading now.
Yes, Dr. Saraf.
My Lord, Rashtrapati, in fact, the state was to give reply.
Reply?
Yes, my Lord, I will have.
You ready?
Yeah, I am ready, my Lord. Now, Your Lordship, kindly see the writ petition. First, I have to take to Your
The
Lordship.
matter regarding VAT.
Yes, and Meghalaya value added tax, and they are questioning the assessment order passed by the authorities, my Lord. Kindly see the prayer, my Lord, because I always start from the prayer, my Lord.
Not from
Page,
court
page
title.
10.
Yes.
Now, the prayer is, my Lord,
Yes.
should not be issued quashing and setting aside the impugned so-called notice dated 9th August 2023, assessment order and demand notices upon cause of being shown, and after hearing the parties be pleased to issue appropriate order or order direction quashing they set aside the impugned so-called notice dated 9/8/2023. So the challenge is, my Lord, the so-called notice and assessment order.
Yes.
This is the challenge, my Lord. Now the basis of the challenge, if your Lordship will see, very simple. Page 3, paragraph 3.
Yes.
That petitioner states that petitioner firm had duly filed their value added tax return under MVAT Act 2003 for quarters ending 31st December 2012 to 31st March 2017. That thereafter petitioner firm received a purported so-called notice number so and so dated 9th August 2020 purportedly under section 36 4B issued by Superintendent of Taxes Circle 2 Shillong. So the case of the petitioner is that this notice has been issued under section 36 4B2 and that was issued on 9th August 2023, my Lord. The notice is also relevant, my Lord, whereas you have failed to furnish a true copy of quarterly returns for quarter ending June 2005 to 2017, so it should be 2012 to 17. Within the specified rule under 32 of MVAT rules, you are hereby directed to show cause in writing on or before why penalty as per provisions of 36 4B MV Act should not be imposed upon you. Failure to comply shall be. So this is the notice which is under challenge before your Lordship. 30th, the so-called notice is under challenge. This your Lordship has seen in prayer 9th August 2023, and this is the so-called notice has been challenged. Now ground for challenge, my Lord, is, if your Lordship will see the ground at page 8, paragraph 7 and 8. that the so-called notice is barred by time, my lord.
Yes.
Paragraph, it is petitioner states that section 55 and 57 of MVET Act provides that no assessment under section 55 and 57 of MVET Act shall be made after the expiry of 5 years from the end of tax period to which assessment relates. So the section quoted is 555 to 57, my lord, and 57 reads as no assessment after 5 years. No assessment under section 55 or 57 shall be made after expiry of 5 years from the end of tax period to which assessment relates. Provided in case of offence under this act for which proceeding for prosecution has been initiated, limitation as specified in subsection shall not apply. Any assessment made or penalty imposed under this chapter shall be without prejudice to the prosecution for offence under this act. Then section paragraph 8 section they state that section 64 of MVAT Act further provides as follows: period of limitation of recovery of tax. Notwithstanding anything contained in law, for time being enforced, no proceeding for recovery of any amount under subsection 1b of section 61 shall be initiated after expiry of 5 years from the date of relevant assessment, provided when appeal or revision has been filed, the period of limitation shall run from the date on which amount due is finally determined, my lord. So these two sections are there, my lord. These two sections say that, if your lordship has noticed, that in section 57(1), the 5 years from the end of tax period to which assessment relates, my lord. So 12 to 17, the argument is that for period 12 assessment year
12 to 17.
yes, 17. 23, my lord.
Was is wrongly shown.
Yes, it is beyond the period of 5 years. That's their case, my lord. If your lordship will see one aspect of the matter, 17, my lord, 17, if your lordship will see this part also, my lord, it says no assessment under shall be made after expiry of 5 years from the end of tax period to which the assessment relates, provided in, so it has to be so their whole case is that my so cause of 9th August 2023 is beyond the period of 5 years.
After assessment year.
Yeah, assessment year. That is the whole case, my lord. But unfortunately, my lord, it's very bad practice, which I say so, my lord, that they have not placed the so-called notices which have been issued to them since 2017. And there is no whisper why those notices have not been placed. I have placed in my counter affidavit those notices.
You put
because your lordship, kindly see my counter.
Yes.
Yes, because that's very unfortunate. Why they are silent about these notices? The lordship will see page 13. Where is that?
It is in my affidavit.
So your affidavit. Notice in your affidavit. Yes, sorry, counter affidavit. Yes. Yes, your lordship will kindly see counter affidavit, page 11.
Yes.
For the purpose of scrutiny of returns, for period ending quarter 31st December 2012 to quarter ending 31st December 2016 under the Meghalaya value added tax submitted by you, you are hereby required to furnish the following information document in the office of undersigned by 19th May 2017, my lord. This is within 5 years, my lord. This notice is of 10th May 2017, my lord, is within 5 years, and this has not been placed. Why it has not been placed? There is no whisper. Because, your lordship, there are judgments and judgments of the Honorable Supreme Court that the petition should be thrown out for concealment of material facts, my lord. I have done. Then second so-called notice, my lord, page 12.
He's reading from item number 3.
I am reading from the first item, item 3.
Item 3.
JB Textile.
JB
Textile.
After that.
JB Textile.
Yes.
JB Textile, my lord. So again, my lord, second so-called notice, your lordship will see for the purpose of scrutiny of returns for period ending 31st December 2012 to 30th June 2017 under the Meghalaya. So so-called notices have been issued within the prescribed period, and this has culminated in the passing of the assessment order.
You mean to say that in the writ petition there's not a whisper?
Not a single. I will read 5-page writ petition, my lord. It's only 5-page writ petition, my lord. before your lordship examine this matter, at least your lordship ask why this fact has been concealed. Your lordship will see paragraph 3, I have read, my lord. Paragraph 4, assessment order was passed. Recently I have seen Supreme Court judgment. On suppression only, petition was dismissed. 39 of MVACT Act, assessment order 45 was passed, hold so and so. Assessment period 2017, so cause notice was issued after more than 6 years, my lord. If your lordship will see paragraph 5, last 3 line, 6 years. What about those records which I have been asking for? And their entire case is, my lord, paragraph 10, my lord, at page 9, that it is beyond the limitation.
Beyond section.
Yes, my lord.
57, 60.
Yes, my lord. And then if it is
Yes.
it's beyond the limitation, my lord. That's the only case they have.
That's some substance of the whole matter.
Only case set up before your lordship. That it is beyond the. Now, if your lordship will see, there is an alternative. If this plea of limitation can also be raised, because there is an appellate authority, revisional authority under the Act, my lord. The provisions, your lordship may kindly see the provisions of Meghalaya value added tax, my lord. Section 65, my lord.
Appeal, revision, review.
Yes, my lord. Appeal against assessment.
No, firstly, it's not a question of appeal right now. It's only been show cause. They have to reply to show cause.
Yes, my lord.
Instead of coming to the court.
Yes,
reply
my
to show cause. Not appeal also.
That is stage.
Appeal has not come.
Yes, my lord. That stage has. So therefore, at this stage, your lordship would interfere, because what is being pleaded before your lordship is a jurisdictional question, because it is barred by limitation. All these aspects will be examined by the assessment authority. You place your
Yes,
case
Dr.
before
Muska, what if you see the other notices which have surfaced now?
My lord, at page 8, my lord, of my petition, I've quoted section 57. My lord, the date of assessment and date of so cause notice. So cause notice is not relevant. My lord, what is relevant is the date of assessment, my lord. Kindly come to page 8 of my petition, my lord.
Then why you have not annexed these other notices which you received?
But that is no relevance, my lord. I'll come to that.
In which, then you show cause?
Page 8, my lord.
Yes.
Section 57, what it says, my lord. I'll just, the quoted portion, my lord. I'll just read. No assessment after 5 years. No assessment under section 55 or 57 shall made after expiry of 5 years. It's not about so cause notice, my lord. It is about the order of assessment.
36, 45.
Then show cause.
And assessment will precede so cause notice, my lord.
Yes.
So my question, my
and my lord, what we have come against is page 13, my lord. This is the assessment order. Page 13, lecture 2, kindly see. Order is already been passed, my lord. Page 13, lord, if lordship sees.
Because it was passed because you failed to reply to the early notices. That is why.
My lord, that will not preclude, my lord. When they have to
The
pass,
thing is that, see,
they have to pass assessment
the thing is
order
that
within 5 years.
They have issued notices to you prior, before and then you didn't reply, most probably.
Yes, my lord.
And so assessment was done unilaterally by them.
But my lord, 5
and
years.
now you've come with a show cause with assessment order. They've made like
My lord, subject to Dr. Saraf's submission, my lord.
Assessment order is under 45, not under 40. If your lordship will see the assessment order, it is under section 45, and there is no limitation under section 45. Your lordship will see the order itself, first line itself, at page 13.
I don't think we'll entertain them. You reply to show cause, whatever
My
somebody
lord, so cause stage is over, my lord. Assessment order, page 13 is the assessment order.
Let them make a decision. That's all.
But assessment order has been passed, my lord.
It's not under section 45, like the article.
Yes, section 45, your lordship will see page 13, 6, my lord. Assessment is made under section 45. Where is the limitation under 45, my lord? And this he can reply, he take up in appeal, revision, and all the statutory remedies are there. And what is being said that those notices are not relevant when the assessment order is based on those assessment notices, my lord. I fail to understand how those notices are not relevant, my lord. Why those suppressions and stay has been obtained on tax matter, my lord? On tax matter?
Subject to item number 3 and 4, my lord, because I'm relying on the submission of Dr. Saraf, my lord. But my only submission to add, my lord, that the bar is on assessment after 5 years, not on so cause notice, my lord.
Even then, whether we
assessment order,
suspicion whether we interfere or not.
Assessment order
basically is that
assessment order is clearly time barred, my lord. Kindly see the period is 12 to 17, my lord.
Take a call on it.
Even for the last assessment year is time barred, my lord, and the assessment year is from 2012, my lord.
Lordship has rightly observed that they do not provide the documents, repeated notice.
That's the only thing that's gone against you, Dr. Muzika, is that if you had come up front with all these other notices that have come and you addressed your case, like by referring to the notices that you earlier received as to why it would be of no consequence to the assessment that was made subsequently and a show cause notice, then maybe you'd have a case for this court. But the very fact that these have been suppressed totally, not a whisper, is a question of suppression.
No question
Whatever
of submission,
any document
suppression.
that deals with a particular, with entity with regard to assessment by any, a tax authority, whether it's relevant or stage of relevancy, that the court will determine. Not for the petitioner to come and suppress and to say that
it's not a very intentional kind of suppression of documents, my lord.
I'm sorry. Yes, Dr. Saraf.
My lord.
Only for that only, because let all the cards be on the table. Yes.
My lord, in my case,
We don't even have the activities.
Yes.
will the AG first reply, my lord, thereafter I will reply by amending the submission.
Yes.
For the same submissions.
One second, Dr. Saraf. Let your file come. Item number?
4.
Item number 4.
Let's point out some last arguments. Just point out the last argument. Then we can start.
Yes.
We can add.
Yes.
Yes, Dr. Saraf.
My lord,
Shall
I was supposed to reply on the last occasion, my lord. I'll be assisting learned AG, my lord. My lord, on the last occasion.
You'll be assisting or what? I don't understand.
You're
submitting, assisting.
I'll be assisting learned senior.
Yes.
My lord, on the last occasion, my lord, learned senior from the side of the petitioner, my lord, they have mainly argued on 3 points, my lord. As far as this present repetition is concerned, my lord, this is pertaining to scrutiny taken up under section 39 of the Meghalaya Value-Added Tax Act, my lord. Their points of arguments, my lord, they have mainly argued on 3 points. First, my lord, that the scrutiny taken up under section 39 is not sustainable in view of the fact that the notice under section 35 was not given by the commissioner to the registered dealer. That is first argument, my lord. The second argument was, my lord, that the law provides that there is 5 years limitation, and therefore the scrutiny taken up under section 39, my lord, that is not valid. And the third argument, my lord, that there was no delegation of power by the commissioner to the superintendent of tax, and therefore, my lord, the entire exercise taken up under section 39 is illegal, my lord. Now, my lord, as far as the first argument regarding the notice, my lord.
The net trading making submission or Mr. AG will make a submission.
My lord, I'll assist. I'll
supplement what on facts.
It's okay. No need to make a hyper-technical submission. Because we are here to adjudicate, Dr. Saraf.
We are here to assist the court.
We
are assisting the court.
Now, my lord,
you are assisting, you are resisting. What to do?
As far as, my lord, the first point which the learned senior has raised as regard to the notice, my lord, I am relying on some of the judgments.
You come this side. Come this side.
Please. Give it sets. This is one set. One more.
Yes.
Which one? First.
Okay, to be fair, 1 second. Dr. Saraf, can you just refresh the court? We have, because I think the matter was taken up some time back, we have totally, just refresh.
I fully agree.
Don't take so long. Just refresh it.
Yes, yes.
I'm short on it.
Yes.
I will make my submission. You know.
Yes.
My first submission for Lordship was that, this order, which was passed,
Yes.
was not an order of assessment. This was an order for scrutiny.
Okay.
Now, the scrutiny of the returns, if your Lordship looks into the provisions, I have quoted in the petition,
Yes. Page.
I have just taken Lordship. Your Lordship, because I was reading my relative, your Lordship may see page 15 of the petition.
Yes.
I read the first subsection only. Each and every return in relation to any tax period furnished by a registered dealer to whom notice has been issued by the Commissioner under Section 35 shall be subject to scrutiny by the assessing authority. So my first submission which I was making for Lordship is that, issuance of a notice under Section 35 by the Commissioner of Taxes is a precondition for the exercise of the powers under Section 39 of the Act.
Okay.
Now, if no notice under Section 35 has been issued, and I relied on the decision of the Superior High Court on the to show to your Lordship that the perimeter provision was there, wherein the notice was not issued, and the court held, that the said order cannot be passed. Now, your Lordship may kindly see Section 35.
Yes. Periodical return.
Periodical return and payment of taxes. It says tax returns so and so shall be paid by manner so and so. Every registered dealer shall in the prescribed manner so and so. Any dealer other than registered dealer referred to subsection 1 shall, if so required by the Commissioner, your Lordship may see subsection 3, by a notice served in the prescribed manner, furnish returns in accordance with the provisions of section 2. So, section 35 notice by the Commissioner is only with regard to the furnishing of the return. If somebody has not furnished the return, then the Commissioner will issue a notice to him under subsection 3 to furnish the return.
Yes.
Now, in a case where the Commissioner has issued a notice to a dealer to furnish the returns, then such dealer returns submitted by the dealer shall be subject to the scrutiny under section 39 of the Act.
By the Commissioner.
By the assessing authority, it says that your Lordship may see section 39 1 second.
It says by the Commissioner there.
Well, the word Commissioner power has been delegated, but I am coming to that also,
Yes.
that there is no power has been delegated. Each and every return in relation to a tax period furnished by a registered dealer to whom notice has been issued under section so and so. So only returns submitted in pursuance to a notice issued under section 35
Yes.
shall be subject to the scrutiny under section 39 of the Act.
Okay. What happened here in this case?
In this case, our submission is that no notice under section 35 of the Act was issued because section 35 notice is required only in the case where no returns have been submitted. Then the Commissioner can direct him to submit the returns. But in the case of the petitioner, since all the returns were submitted in time, the question of issuance of any notice under Section 35 does not arise.
Yes.
And rightly, therefore, the Commissioner had not issued any notice under Section 35 of the Act.
Yes.
And since this is a precondition of Section 39, my Lord, in a case where Section 35 notice had not been issued, the power under Section 39 of the Act cannot be exercised.
Okay. Yes.
The second submission which I was making for Lordship of my Lord, that for the purpose of in Section 57, your Lordship is my Lord,
Yes.
the time limit.
Limitation.
Limitation. That limitation, your Lordship, may once again kindly look into it, my Lord. 57. No assessment after 5 years.
Yes.
No assessment under Section 55 or 56.
Yes.
Only 55 and 56, my Lord, shall be made after expiry of 5 years from the end of the tax period to which the assessment relates.
Yes.
So the limitation which has been specifically prescribed is for Section 55 and 56 of the Act. Now, 55 is audit assessment, my Lord.
Yes. Yes. What do you want to say, Dr. Saurabh?
My Lord,
Audit
so I was
assessment.
submitting, my Lord, that
Yes.
section, this 59, which provides for the limitation of 5 years, is only for Section 55 and 56 of the Act, that is audit assessment others. No limitation has been provided for.
Even 57 provides only, it covers only 55 and 56. That's your argument.
So for others, no period of limitation has been prescribed.
Yes.
Now the Apex Court, my Lord, I placed on the last occasion the judgments of the Apex Court. This said, my Lord, that when no period of limitation has been prescribed, then the limitations should be considered to be the reasonable period. And the Apex Court held, my Lord, the reasonable period has to be construed on the basis of the scheme of the Act.
Yes.
Now, in the Act, even after for reassessment also, for show motor revision also, the maximum period is 5 years.
Yes.
Beyond 5 years, there is no period prescribed under the Act. The Apex Court, therefore, in the particular circumstances of that case, held that the maximum period of limitation which is prescribed under the Act should be taken to be the period of limitation where no limitation is prescribed.
So your submission is that 5 years will be reasonable period in your case also.
So my submission is that, when the maximum period of limitation for other purposes
Yes,
is
5 years.
only
Yes.
5 years, then because what I was submitting, if for assessment, if for audit assessment, the 5 years limitation is there, then for scrutiny, how it can be said, that the scrutiny will be on of 10 years or 15 years.
Yes.
Even in the case, where there is escapement of the turnover and the assessment has to be completed, reassessment has to be completed, then also the period of limitation is only 5 years.
Yes.
So, on that also I relied on the 2 decisions of the Tripura High Court,
Tripura High Court.
One was Tripura High Court, division bench. One was WBC 1909.
Yes. Pankaj Bihari Saha.
Pankaj Bihari Saha. There I was referring to your argument, the para 12.
Para 12.
My lord. Where section 27 was of the Tripura VAT Act was under question. And also find section 27 scrutiny of returns.
Yes.
As you also got it.
Yes.
It says each and every return in relation to any tax period furnished by registered dealer to whom notice has been issued by the Commissioner under section 24 shall be subject to the scrutiny. So exactly same phraseology, which has been used in section 39 of the Act. Now, here also, the notice was not issued by the Commissioner, and you'll also see para 20, First of all, I may take you also, the better 15, para 15.
Yes.
All the provisions noted contained in Chapter 5 of the Tripura VAT Act pertaining to returns assessment thus provide for detailed procedure for requiring a dealer to file periodic returns of his turnover, for audit assessment of such returns, if so desired, and also to address the issues of turnover escaping assessment. The relevant provisions, section 24 to 27, needs to be looked into from the angle of the scheme contained in Chapter 5 of the Tripura VAT Act concerning returns and assessment. Subsection 1 of Section 24 requires every registered dealer to furnish return in such form by due dates as may be prescribed. A registered dealer is thus obliged to file the return mandated under subsection 3 of Section 24 of the Act. Subsection 2 of Section 24, on the other hand, refers to a case of a dealer in respect to whom the Commissioner has reason to believe that his turnover of sales has exceeded the taxable limit. The Commissioner would serve a notice in the prescribed manner requiring such dealer to furnish return as if he was a registered dealer. Subsection 2 of Section 24 thus covers a case of a person who may not be a registered dealer and in whose case the Commissioner reason to believe that the turnover of the sales exceeded the taxable turnover. Section 27 of the Tripura VAT Act contains the scrutiny returns. Subsection 1 of Section 27 provides that every return in relation to any tax person furnished by a registered dealer to whom notice has been issued by the Commissioner under Section 24 shall be subject to scrutiny by the assessing authority to verify the correctness of the calculation, application of the correct tax rate, interest and input tax credit, claim therein, and full payment of tax and interest payable by the dealer during such period. Subsection 2 of Section 27 provides that a mistake is rejected as a result of the scrutiny, the Commissioner of Taxes shall serve a notice in the prescribed form to the dealer to make payment of the extra amount of tax with the so-and-so. Section 27 of the Act is thus not a provision for full assessment of the return filed in response to the notice issued by the Commissioner under Section 2 of Section 24 of the Act. It is merely for the purpose of verifying the correctness of the necessary details furnished by such return as calculation, application rate of tax interest as well as the payment of tax and interest by such dealer. If an error is detected by the such aspects under subsection 2 of section 27, the Commissioner would issue a notice recovering the balance so. The provisions contained in section 27 are vastly different from the provisions of self-assessment under section 29, provisions of assessment under section 30, and most significantly, the audit assessment under section 31 of the Act. The special powers can be exercised only in relation to a dealer to whom notice has been issued by the Commissioner under section 24 of the Act. Section 24 refers to issuance of a notice only under subsection 2 of the Act. Necessarily, therefore, unless and until such a notice is issued in terms of subsection 2 of section 24 of the Act, the TVT activity cannot invoke the powers under section 27 of the Act. Any other view would defeat the very scheme of the chapter providing for audit assessment and limitation for completing the assessment as provided.
The limits be taken as 5 years. We have to constitute the exemption period. Yes. Next
under section 33 at the Act. So, my this judgment, of the Honorable Tripura High Court is exactly on the same issue, that without issuance of a notice under section 34 of the Act, the scrutiny of the returns under section 39 cannot be made. Now,
I was requesting a copy of the judgments which are being referred so that we can meet those judgments.
You have the judgments?
No, we don't have the judgment. Without
I
supplying
think
the
last occasion, I think the judgment.
No, it was not given.
List of books you have given.
Not
Who's the
given.
local counsel, Dr. Saraf?
We were not supplied.
We,
Sorry?
my friend
Who's
is
the local counsel?
Local council. Miss Rakhi Paul.
Miss who?
Rakhi Paul. In fact, the state council has not requested on the last 3 occasions.
I'm there now.
was not
I have
supplied,
go
no.
through the judgments now.
No, no,
Those judgments are being relied upon, so then at least I should have copy to deal with those judgments.
Lani Reggie Miller, on the last 2 occasions when the state council appeared, he had never asked for copy, otherwise we would have supplied.
Otherwise, also copies should have been supplied.
No, at least
No,
Dr.
I
Saraf,
don't-
yeah, Dr. Saraf, only sorry, like let's not digress. The only thing is that if at least you keep a local counsel here who can give your
No,
list of
local council is
citations.
there, my lord. Local council has been engaged.
I don't
in
see
this.
any local
Rakhi
counsel.
Pal- No, my lord, generally she should have been there. There are Miss Rakhi Pal.
I'm sorry, I can't arrange that for you. That who
No, no, no,
local
no,
counsel
no,
appears for you.
my lord, I am sorry,
Make
my
sure
lord,
local counsel appears.
my lord, when we engage the local
You
counsel,
can't put them at a disadvantage also. You have to supply the citation at least. Will adjourn it to Tuesday?
Yes, I'm sorry to, my lord, I'm sorry to say, my lord, one thing, my lord, the learned AGC may say anything, but
But I'm
when
not
the
saying
3 times,
anything.
my lord,
I
the
need
state
judgments.
council-
Whatever judgments you are relying
Let's
upon.
not get petty. It doesn't matter. But the thing is that if the matter can't go forward, then we'll fix on Tuesday all the matters. Yes. On a prayer of the council parties, list the matter. We'll have Tuesday. We'll complete them kindly.
Yes, madam. But I would request that in the if the
Yes,
copy.
of course.
Yeah.
List of.
My lord, we will do, well, I will do one thing, my lord, I will ask the unit council to supply all the copies by
Yes,
mail
yes.
to the
Yes,
learned AG.
yes. I'm grateful.
Mr. Dr. Saraf undertakes to supply all the authorities relied upon by email
And in
to
case, my lord,
the
in case the learned
I will also.
RPA General, and
No, no,
RPA
because
General
I mean,
likewise,
anything
if
else-
any other judgment relied upon will be
We will-
exchanged between the parties. Yes.
Item number 6.
The interim order kind of till next day.
Yes.
Your Lordship, the senior is just coming. This matter was last.
Yes.
Wait, please, Your Lordship. Lord, this is that issue where taxability of annuity contracts was under consideration. But on the last date, I had given an overview of the issue. If my Lord recalls, there was a GST Council decision to exempt annuity contracts. That decision culminated into an exemption notification.
Yes.
We claimed that exemption. For 4 years, there was no concern. In 2021, a circular comes to be issued by the department. And they say that that exemption is not applicable to projects which are construction projects. The circular is predicated according to them on a certain classification, 9964, etc. And that classification according to them points that it is not meant for construction projects.
The circular is 21.
That's 21.
Yes.
And that circular is the basis on which the assessment order comes to be passed against me. So what my lord will have to interpret is whether the circular is correct, because that is the edifice of the demand, whether construction is a negative covenant for this exemption, because if I am doing construction, then I'll be very fair, I have no legs to stand. I had said that in the last occasion also. What is also relevant is that this circular was on the back of a GST Council meeting itself, which happened 4 years thereafter. There the GST Council took a vote face from what they had taken 4 years back. So the point for consideration for my lords at this stage is a project or a concession agreement of this kind, which is for annuity, is it a contract for construction? Because similar exemption has been accorded to toll contracts.
Yes.
And I had explained annuity,
recall
toll,
it, right.
the only difference is the compensation origin. And I had also mentioned that apart from the validity of the circular and hence the adjudication order, we are also challenging the power of the person who issued the show cause notice. In fact, my lord recalls this is the second round of litigation. I had come before my lords at the show cause stage. At that point in time, I was armed with a decision of the Karnataka High Court, single judge,
Yes.
which my learned friend said that it is too premature. We don't know whether the authorities will agree or disagree. It is futile to take a view today. And my lords were pleased to relegate me to say, let them take a view.
Yes.
We furnished that judgment before the lower authority and he sidesteps that completely. So my root cause from the beginning was the authority who issued the show cause notice. Was he so empowered to issue the show cause notice? That's the second aspect of the matter. The third aspect of the matter is, this show cause notice was issued under section 74 of the CGST Act. There are two sections, one is section 73, other is section 74. 73 is where your normal period of limitation apply. 74 is where there is a suppression. So they invoke section 74, saying that we had suppressed. Now limitation, my lords have held, is a question of jurisdiction. That was what being argued by Dr. Saraf also. It is a case where for 4 years, there was no whine or whisper from them. Life was good. 2021 circular creates the problem. Substantial part of my demand period, which is 2017 to 2022 December, is prior to the circular. Under that circumstances, can suppression be at all alleged? Had it been the case that circular was hand in hand with the notification?
So you see notifications that was issued 4 years prior.
4 years prior.
So 17.
Correct.
Where that now this
Now
circular has gone
contrary,
yes,
bold
contrary to
face.
notifications, yes.
Now they say it is a suppression. Basis that circular itself, that it was never intended, you never reported, you never told us, etc. So therefore section 74. That's the third limb of my challenge. The fourth limb of my challenge was that they themselves say in their adjudication order that it is a construction project, assuming they're correct. They also said that substantial part of the project was completed prior to GST. because today is the 8th anniversary of GST. 1st July, 8 years back, is when GST came into force, 2017. They say that my project was completed, construction was completed prior to that. If I go by what they are saying, that the construction is the heart and soul of this particular project, then the construction work was completed according to them prior to GST. Under that circumstances, does the GST Act have jurisdiction to levy tax on transfer of property that may have taken place prior to that? That's the fourth limb of my...
Yes.
Again, it's a jurisdictional issue. And the fifth limb, well, this company was taken over by the current petitioner pursuant to an insolvency resolution that had happened. Well, recalls that about 4-5 years back, ILFC as a group went through a huge financial crisis. In fact, the Ministry of Commerce, Ministry of Finance had to initiate proceedings against that company, change the directors and directed that it should go through an insolvency process under the Companies Act. And pursuant to that, bids were called out, and I was one of those people who bidded for that. And there is a cut-off date as per the NCLT that demands of tax prior to a certain date is to be waived. The interesting part is that the initiator of that proceeding was the Union of India. And I'll show those. So the cut-off date was 2018, somewhere in 2018. So at least for 1 year, there is a waiver of tax for me. If everything falls, assuming that I don't succeed on any of the 4-5 limbs, at least that much protection should have been accorded to me, which they also deny for reasons which I'll explain.
You mean the resolution process, that was, the waiver was in black and white?
Yes, NCLT order is on record. It was placed before them also. The contention is, Meghalaya state says that I was not informed about this proceeding. Nobody told me so. I say, I made a publication. Times of India or Economic Times, the publication was made. Initiator of the resolution was the Union of India. The Government of India was the petitioner. Government of India was aware of it. Now, if one hand knows about it, the other hand to turn back and say, I was not told, was something very strange. Then it is between them to figure out how do they take out the, because GST is the CGST and SGST both. So that's the conspectus. Now, I was trying to explain the 4 or 5 fallacies. In the first aspect, that it's a contract for construction.
Yes.
Now, if my lord takes the notification that we are concerned with, may have page 408.
This is volume.
This is volume 2, right? Volume 2.
Or 8.
408.
Yes.
This, my lord, will see the notification number is 32 of 2017.
One second.
Sorry.
Yes. 13 October.
13th October 2017.
Yes. Yes.
If my lord comes to the next page, in the middle of the page, there is a table, 23 capital A.
Yes.
Heading 9967, which is the bone of contention, that's the root of the matter. Services by way of access to a road or a bridge on payment of annuity. The GST applicable is nil, and there are no conditions attached. This is the notification. Now, the similar notification for toll, my lord will find at page 386.
86 is,
386 entry 23.
I think. Okay, yes.
Yes.
Heading 9967.
Yes, entry 23, which was the first entry that came. So 23A is a further addition.
Nil.
9967, services by way of access to a road or a bridge on payment of toll charges, nil. The distinction between 23 and 23A is the word annuity and toll. Everything else remains the same.
Yes.
Now the reason why this 23A was introduced can be found at page 370. This is the 22nd GST committee agenda. Will Lord sees that?
Yes.
In fact,
This is the issue annuity being given in place of toll charges.
correct, because toll was exempt, therefore we wanted to exempt an annuity. Toll is exempt from GST. In service tax, it was in the negative list. There is a difference between toll and annuity. I'm sorry,
My brother's not working.
370.
370. Yes.
What has that? In fact, the agenda starts at 361. I'm reading the operative part, which is at page 370. Issue of annuity being given in place of toll charges to developers of public infrastructure, exemption thereon. Toll is exempt from GST. In service tax, it was in the negative list. Now, toll is exempt from GST. I've shown that entry, that notification I've shown.
23.
Yes, 23. There's a difference between toll and annuity. While toll is a payment made by users of road to concessionaire for usage of the road, annuity is an amount paid by the NHAI to the concessionaire for construction of roads. In other words, annuity is consideration for the service provided by the concessionaire to NHAI.
Yes.
That is the distinction. And at para 6, a view may be taken for grant of exemption to annuity paid by NHAI state highway authorities to concessionaire for construction of roads. I'll pause here. Therefore, the intention of the lawmaker
So to put it at par.
to put it at par.
Yes.
What is sauce for the gander is sauce for the goose. Now, in the minutes of the meeting, this was the agenda. The minutes of the meeting of GST is at page 377, volume 2, same volume. So it's the other volume.
No, next volume.
Yes.
Yes.
At the foot of the page, para 61. Page 377.
Agenda 13.4.
Yes, agenda item 13.4. So the agenda is now being deliberated upon. Introducing this agenda item, the Joint Secretary TRU Central Board of Excise and Customs stated that while toll is payment made by the user of road to concessionaire for usage of roads, annuity is an amount paid by NHAI to concessionaire for construction of roads in order that the concessionaire did not charge toll for access to road or a bridge. In other words, annuity is a consideration for service provided by concessionaire to NHAI. He stated that construction of roads was now subject to tax at the rate of 12%, and due to this there are free flow of input as credit from the EPC contractor to the concessionaire thereafter to NHAI. He stated that as a result, tax at the rate of 12% leviable on service of road construction provided by NHAI to concessionaire to NHAI would be paid partly from input tax credit available with them. He stated the council may take a view for grant of exemption to annuity paid by NHAI to concessionaire during construction of roads. He added that access to a road or bridge on payment of toll was already exempt from tax. The Honourable Minister from Haryana suggested to also cover under this provision annuity paid by state-owned corporation. After discussion, the council decided to treat annuity at par with toll and to exempt from tax services by way of access to a road or bridge on payment of annuity. This is that exact line that my lord will also find in entry 23 capital A, the last line. So the intent was very clear. Put them at par. If they are exempt, toll is exempt, you are also exempt. Now, 4 years later,
Where's the circular?
yes, the circular, my lord, is at page 158.
Digital. 1.
158, volume 1. Annexure 2.
This is the 17th June.
17 June 21, the root cause,
Yeah.
which is after 4 years from 2017. That's the other important attribute. May I read?
Yes.
Certain representations have been received requesting for a clarification regarding applicability of GST on annuities paid for construction of road, where certain portion of consideration is received upfront while remaining payment is made through deferred payment annuity spread over years. The issue has been examined by GST Council in its 43rd meeting held on 28th May 21. GST is exemption service falling under 9967 by way of access to road or a bridge on payment of annuity, entry 23A of the notification 2017. Heading 9967 covers supporting services in transport, under which code 996742 covers operation services of National Highway Authority, expressway, roads and streets and tunnel operation services. Entry 23 of the said notification exempts services by way of access to a road or toll on payment of toll. Together, the entries 23 and 23A exempts access to road or bridge, whether the consideration and the form of toll or annuity, heading 9967. Services by way of construction of road falls under 9954. This heading inter alia covers general construction services of highways, streets, road, railways, airfield, runways, bridges, tunnels. Consideration for construction of road services may be paid partially upfront and partially in deferred annual payment and may be called annuities. Said entry 23A does not apply to services falling under heading 9954. It specifically covers 9967 only. Therefore, plain reading of 23A makes it clear that it does not cover road construction of road services falling under 9954, even if deferred payment is made by way of installment annuities. Accordingly, as recommended by GST Council, it is clarified that entry 23A of notification 2017 does not exempt GST on annuity deferred payments paid for construction of roads. So they say that what you do is the construction of road. It is not intended to cover that and therefore not applicable. What they forget is the agenda, 21st meeting agenda, 22nd meeting agenda specifically made a reference to construction of road. For a minute, if I may trouble, we'll have to come back to 370. Volume 1.
Yes.
Para 2. There is difference between toll and annuity. While toll is payment made by user of road to concessionaire for usage of road, annuity is an amount paid by National Highway Authority of India to concessionaire for construction of roads.
Yes.
So while issuing the notification, construction of road was the key parameter that went into consideration. And that also comes out at para 6. A view may be taken for grant of exemption to annuity paid by NHAI to concessionaire for construction of roads. Again, the word construction of road gets repeated here. This agenda item gets replicated at page 377, volume 2. The very first 3 lines, para 61.
Yes.
Introducing this agenda item, JSTRU CBEC stated that while toll is payment made by users for road concessionaire for usage of road, annuity is an amount paid by NHAI to concessionaire for construction of roads in order to the concessionaire does not charge toll. So construction. So the fine distinction that is being sought to be drawn by the revenue 9964, 9954, whatever, to say that if you are construction, you don't get this benefit, was never there in the anvil at the time the exemption notification was issued. Now, be that as it may, I now go to explain the 3-4 fallacies in the very view that has been taken, all of which leads to one conclusion, that the circular is patently illegal, apart from the fact that it has been issued by an authority who is a persona non grata, which I'll come to. Now, let me take the first fallacy. To say that a concession agreement of the present kind is a contract for construction simpliciter is to say that they don't even understand what a concession agreement is in reality. I had on the last occasion submitted that in a 20-year period, which is what the concession period is, 3 years, 90 days is what it takes to construct the road, the highway.
Yes, yes, yes.
17 years is to operate and maintain. It is not the case that after the 3-year, 90-day period, I go home, pack my bags, and I receive the money for the next 20 years, next 17 years. That's not the case. I am invested in the project for 20 years. I do various activities which I'll show. And on the end of the 20th year, there is a vesting of the property in favor of NHAI through an official document. Until then, I am possessed of the asset and I operate the asset. That's the first and foremost thing. There is a fundamental contradiction in what they say at a latter part of the order original, which I would like my lord to immediately take my lord's view on that. Page 122, para 4.11, volume 1.
Para?
Para 4.11.
Page?
Page 122.
122.
Because in this paragraph, they admit that it is not a construction simpliciter.
Para 4.17.
4.11.
4.11, okay. Yes.
The last phase of the project was completed in January 2014. Well, this is what I was saying. 2017 is when GST came into effect. Last phase of the project was completed in January 2014, but the deferred annuity payment are being received by them on the recurring basis as per the concession agreement with effect from 10/7/2014, which shall continue till 6/1/2031. Apart from the construction, operation and maintenance of roads, all other rights over the road, including levy of user fee, toll fee, vests with NHAI as evident from the statement deposed by authorized signature notice and the concession agreement. Therefore, it is evident that notice has been providing a continuous supply of services for construction and maintenance of the road. They gobbled up the word operation, but doesn't matter. But they understand that it is not a pure simpliciter construction. For construction and maintenance of the road, an annuity being paid to the notices for services where the major portion of the service rendered is covered by the construction and maintenance of the road. Of the services which falls under SSC 9954 and therefore not entitled for exemption under serial 23 of the notification. That the latter part is the bone of contention. So the short submission I make on this is that they themselves record that it's not a construction simpliciter. There is another very important aspect that comes out. In the very second line, payments are being received by them on a recurring basis as per concession agreement with effect from 10/7/2014. That's very fundamental. Last phase of the project completed in January 2014, and payments come into being after the project is up and ready for operation. So annuity triggers from a commercial operation. If it was pure construction, then I would have got paid on a milestone basis as I construct or at the end of the construction. But the fact that my payments of annuity is dovetailed to the operation of the project which provisions I'll show a little while from that. Since they have recorded it, I want to show this is not a disputed question of fact. Goes to establish that the contract is far beyond construction. Far beyond construction. That's the second point that comes out from this paragraph. So the three things that comes out. Four things. The substantial part of the project last phase was completed in January 2014. They admit of that.
July 2014.
Yes. Second, they say that payment were made after that, after completion of the construction. Payment started. Third, it is not only construction, but it is other things, maintenance. And fourth, the last line is the gravamen of the issue that you are doing construction. 23A does not apply to construction. This is a universe. This paragraph is the universe, therefore.
Yes, not forbidding under 23A.
Correct. Since you are doing construction,
You're not entitled.
23A does not cover, therefore you are not entitled.
Yes.
Now, may I draw my lord's attention to my contract. If my lord takes the contract which is at page 196,
Yes.
this agreement is entered into on 16th July 2010. 16 July 2010 is when the agreement was entered into. Now the scope of the contract is at page 205. Para 2.1. The scope of the project shall mean and include during the concession period construction of the project highway on the site set forth in Schedule A and as specified,
Yes, yes.
as specified in Schedule B, together with provisions of project facilities as specified in Schedule C and in conformity with the specification standards set forth in Schedule D. B. Operation and maintenance of the project highway in accordance with the provisions of this agreement. And C. Performance and fulfillment of all other obligations of the concessionaire in accordance with the provisions of this agreement and matters incidental and thereto or necessary for the performance of any or all of the obligations of the concession under this agreement. Had the contract stopped at clause A, things would have been different.
Only construction.
Correct. But that is not the case. In fact, the term concession, the very next page, para 3.11, 206. Subject to and accordance with the provisions of this agreement, the applicable laws and applicable permits, the authority hereby grants to the concessionaire the concession set forth herein, including exclusive right, license, and authority during the substances of the agreement to construct, operate, and maintain the project, which is therefore defined as concession, for a period of 20 years commencing from the appointed date. So that's the scope of the concession. Now 3.12 is very fundamental. Subject to and in accordance with the provisions of this agreement, the concession hereby granted shall oblige or entitle as the case may be the concessionaire to. Kindly see clause C. Subject to clause 3.12d, manage, operate and maintain the project highway and regulate the use thereof by third parties. Lord, the word regulate the usage by third party can not mean anything other than permitting access to the road. What kind of regulation do I do? So the grant of access to the road, which is the description in the notification, granting access to the road, comes out from here itself. Subject to clause 3.1 to do, manage, operate and maintain the project highway and regulate the use thereof by third parties. Then clause D. Allow and assist the authority or authorities contractors in demanding, collecting and appropriating the fee from vehicles and person liable for payment of fee for using the project highway or any part thereof and refusing entry of any vehicles if the fee due is not paid. This is also very important. Here the word fee means the fee or the toll collected by NHAI. So NHAI will collect toll. I shall refuse access to my road if they fail to collect the tax. Again, access to road is also regulated. This is the other way of regulating the thing. So those Clause C and D makes it abundantly clear that I grant access to road as part of the overall basic structure of this particular concession. Now, my lord, I had also explained on the last date that distinction between BOT annuity and BOT toll, the commercial difference, apart from the fact that remuneration is the difference, toll is collected from the user, annuity is by NHI. The commercial difference was, when I bid for a toll project, the risk of traffic is on the concessionaire. So if it is a 1000 crore highway, I estimated traffic of, let's say, 2000 vehicles a month. And on that basis, I project my cash flows and my financials. Assuming it is not 1000 vehicles per month, it is 500. I'm in the dock. I'm in the red.
Right, yes.
So in a toll project, the risk of traffic is on the concessionaire. The government of India found that people were not very interested in that model anymore. They said, okay, fine, we will shift gear. We'll make it into an annuity model. So the risk of traffic is on NHI.
Yes.
Therefore, NHI will collect the toll.
Yes.
And you, Mr. Concessionaire, your pockets will be filled by me, NHI. As an annuity.
Ensure only that the road is in good condition.
Make sure that road,
access,
precisely.
Yes.
This is the commercial distinction between the two, apart from the factual difference that toll is collected there. It's correct. Now, I would like, my lord, to also look at page 210, article 5.11.
Yes.
Page 210, article 5.11.
Yes.
Obligation of the concessionaire. Subject to and on the terms and conditions of this agreement, the concessionaire shall at its cost and expense procure, finance for and undertake to design, engineer, procurement, construction, operation and maintenance of the project highways and observe, fulfill, comply with and perform all its obligations set out in this agreement. Expansive. Now, page 252.
Large scope.
Page 252.
Yes.
Is very fundamental because this reflects upon the access to the road. Page 252.
Traffic regulation.
Traffic regulation. Mr. Bhattacharya has that. Traffic regulation. I did not labor going through the details. The very substance traffic regulation goes to show that what I am doing.
No, what issuing is just show the scope.
Correct.
That's all.
Correct.
Nothing else. Yes.
And 253 is emergency and medical aid. It's far beyond construction. 254 traffic sensors and sampling. All of this goes to show the access part. Then, my lord, the next part of the concession agreement is at 221, which is development and operation.
221 page.
Page 221.
Go back.
Part 3. Who has that? 221.
Yes. Yes.
Yeah, that's the development and operation. So far, I've shown the construction. This is the development and operation, which is the other aspect of the whole thing. And in that, 235, page 235. Para 14.2 talks about a completion certificate. Upon completion of construction works and the independent engineer determining the test to be successful, he shall forthwith issue to the concessionaire and the authority certificate substantiated in the form set forth in so it's called the completion certificate. So on construction completion, I get a completion certificate. Now what happens is, at page 261, para 27.11.
Para
27.11, page 261,
annuity.
annuity. Subject to the provisions of this agreement, the concessionaire, upon achieving commercial operation date for the project highway and in consideration of the concessionaire accepting the concession and undertaking to perform and discharge its obligation in accordance with the terms, conditions, covenants set forth in the agreement, authority agrees and undertakes to pay the concessionaire for each annuity payment period on each annuity payment date as set forth in Schedule M, annuity payment schedule so and so. Which means the payment triggers, as I mentioned, after conclusion of construction when the commercial operation is ready. So it's not a pure simplicity for payment for construction. Then may kindly have page 242.
Page 242.
242. So far we spoke about the construction, here is the operation maintenance. 17.1.1. During the operational period, which is the second phase, the concessionaire shall operate and maintain the project highway in accordance with this agreement either by itself or through the O&M contractor, and if required modify, repair or otherwise make improvement to the project highway to comply with the provisions of this agreement, applicable laws and applicable permits, and conform to good industry practice. The obligation of concession sharer shall include permitting safe, smooth and uninterrupted flow of traffic on the project highway during normal operating conditions. This is again reflective of the access part.
And next one, tolls.
C. B is allowing an assisting authority or authority in collecting toll and appropriating the fee. So I can't collect the toll, NHI will. Again, the access part. C. Minimizing disruption of traffic in the event of accidents and other incidents affecting the safety and use of the project highway by providing rapid and effective response and maintaining liaison, etc., etc. And there are a whole host of things that are there. I will not trouble my lord with all of the detail. The substance of this entire chapter, Article 17, is to show how I do beyond construction into the operation and maintenance of the project.
Yes.
At page 259, para 25.1.1. Who has that?
Yes.
The concessionaire shall not levy,
Yes.
demand or collect from or in respect of any user, vehicle or person for the use of the project facilities any sum whatever in nature of a toll or a fee. So clear restriction on me from claiming toll. Because if you guys are permitted to claim toll, then I would have been that BOT toll model.
No, it's fine. We understand the
Right.
lines are clearly drawn.
Right.
I mean, yours is not only what you're impressing upon the court. It's not only limited to construction. It goes beyond that.
Correct.
Maintenance.
Correct.
It's like working hand in glove with NHI to ensure a collection of tolls, so on and so forth.
Precisely. I'm so obliged, my lord.
Yes.
I'm so
That's-
obliged. Correct.
Yes.
Now, if that be the case,
Yes.
the finding of the authority, which my lord will come to page 121, para 4.7, volume 1.
121.
Yes. Or the impugned OIO.
Yes.
Para 4.7. May I read, my lord?
Yes.
The said entry 23 capital A clearly says that only those services by way of access to a road or bridge on payment of annuity which is under 9967 are exempted, while said entry 23A. A plain reading of SSC 9967 clearly shows that this SSC is related to services wherein if any charge fee is collected for accessing the road or bridge, that particular charge fee will be exempted from GST. However, it does not exempt the services covering construction of road, as the construction of road comes under SSC 9954. During 43rd GST Council meeting 28/2021, the issue was further discussed and it was clarified that 23A of notification 17 does not exempt annuity for construction of road. Subsequently, board issued circular dated 2021, which is as follows. I have already read out. Therefore, plain reading of 23A makes it clear that it does not cover construction of road services falling under 9954, even if deferred payment is made by way of installment of annuities. Composite supply of contract, worst contract supplied by way of construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, renovation or alteration of road, bridge, tunnel and transportation for use by general public have been classified 9954. As the agreement between NHAI and the notices for construction maintenance of road, the services rendered by the noticee comes under SSC 9954 and therefore not entitled for availing exemption under 23A.
Yes.
This is their government. And then para 4.11, which I have already read out earlier.
Yes.
Now, therefore, two things comes out for consideration. How does one read this notification? Especially the word classification referred to therein, because they seem to be going on the classification 9964, 9954, etc. That whole ecosystem. Now, there are two layers to this issue. First, is this classification a condition precedent to this notification? The notification is in three parts: classification, description, rate. They don't say that I don't fall under the description. There's no whisper on that. They say this classification you do not satisfy because that classification is not meant for construction, you do a construction. So how critical is this classification in applicability with this notification? That's the first aspect of that. Second aspect of that, assuming what they're saying is correct, the classification is really important. Am I a construction? The latter part I have explained that I am not a construction. I am far more than that. And the aspect of access to road is more than replete through various clauses of the concession agreement. What therefore falls for consideration is how critical is this classification.
See, one thing, Mr. Ghosh, like 4.9 they say, plain reading entry 23A makes it clear does not cover construction of road services. Now, why have they added the word services to make it fall under heading 9954?
Yes. I'll therefore it will require appreciation of this classification. It will go back to this classification.
It'll just revolve around that.
Right, absolutely.
That's
absolutely.
Thing, yes.
Now, moving detached from this particular brief, let us say NHAI wants to get a road constructed and operate it themselves. Possible. They are highway authority, they can operate themselves. They can maintain themselves. They go to an L&T, for example. I'm taking the name not for any specific reason. They go to L&T. Please, can you construct this road? He says, okay, I will construct. Give me a fee for that. That is what is called a typical engineering, procurement and construction services. So 9954
yes.
pertains to those kind of projects where there is the construction of road services. The services of construction of a road.
Okay. No ancillary.
No ancillary thing, no operation, no maintenance, no transfer, no divestiture, no commercial operation period, no anything.
Tender.
It's like a pure construction tender.
Okay.
And such projects happen. That's called the contract model. But PPP is different. Public-private partnership is different, where the private party is partnering with NHAI would have done, which is operate and maintain. That's the distinction between a pure construction contract and a PPP project. Now, coming to this classification, it is our respectful submission that this classification is a surplus, is a vestigial. It has no relevance whatsoever in interpreting notification. Why do I say that? For that, my lord will have to peruse the original notification, because 23A was an amendment. If my lord goes to page 380,
back to 17.
Back to 17, original, not 23A, but the original notification.
Page of this
Volume 2.
Yes.
May I read the preamble? And before I read the preamble, my lord takes a look at the table. Serial number 1 is just 1, 2, 3, 4,
Yes.
not consequent. Serial number 2, or column 2 is the classification. Chapter, section heading, group or service code.
Yes.
This is where 9964 or 9967 in 23A comes in. Column number 3 is the description of service. 4 is rate and 5 is condition.
Yes.
Now, keeping this construct of the table, may I read the preamble? In exercise of powers conferred by 11(1) of the CGST Act, the central government, on being satisfied that it is necessary in public interest so to do on the recommendation of the council, hereby exempts the intrastate supply of services of description specified in column 3 of the table below from so much of the central tax leviable thereon under subsection 1 of section 9 of the said act as is in excess of the said tax calculated at the rate specified in the corresponding entry in column 4 of the said table, unless specified otherwise, subject to relevant conditions as specified in the corresponding entry in column 5. So, column 3, column 4, column 5 has been made a mention in the operating part of the notification. Column 2 does not have any mention at all. I would understand if the notification were to say, goods falling under this chapter of this description, then that would have been fundamental. Then you need to satisfy both the conditions. But the legislature was very conscious and made a reference only to the description. Now there is a reason for that. The reason for that is page 407. At the end of this notification, they explain.
Yes.
Third explanation is an italicized explanation. For the purpose of this notification, now kindly see clause 2. Chapter, section heading, group or service code mentioned in column 2 of the table are only indicative. And that's very vital. Had it been a case that it was fundamental, then the language would have been wholly different. Not only that, the prior clause, clause 1 of the same explanation, reference to chapter, section or heading wherever they occur unless the context otherwise requires, shall mean respectively as chapter, section and heading in the scheme of classification of service. Two things are relevant therefore, unless the context otherwise require. So ipso facto you will not go to the classification. And B, to understand what the classification is, go to this scheme of classification of service. My submission is the context in this was not this classification but the access to road, that context, or the contemporaneous exposition that was there.
Yes, we get it.
Right. Now, my lord, I would now request my lord to see what is 9967 and 9954. The rejoinder, my rejoinder to the state's affidavit. In fact, last time this is where we had to halt because state said that they don't have the copy of the rejoinder, but they did have. Nonetheless, kindly have page 104 of the state's, our rejoinder to the state's affidavit.
This is by respondents 1, 3, 4 and 5.
2 and 7.
2 and 7.
2 and 7.
Yes. The state is 2 and 7. And the identical thing is against the center's affidavit also, just for completing.
359. Yes.
Page 104.
Yes.
Lord, left hand side serial number 125 may be seen.
9967.
9967.
Yes.
Supporting services in transport. There are various kinds of subcategories are there, and at serial number 140, is operation services of national highways, state highways, expressways, roads and street.
This is page 463 of this. 463, like the day. 463, look at the page, my court position. That's right. 463. 463. Done. 463. The 1 through 4 internal pages. 463, 1 through 4 internal. 1 through 4 internal. Go ahead. Yes. Heading
Read it, bro?
9967, right?
Yes. 9967 is at serial number 125
Yes.
and 140 is the relevant subcategory.
Yes.
996742.
Yes.
Operation services of national highways, state highways, expressways, roads and streets, bridges and tunnel operation services. This is what this classification is about. Now, this is one way of looking at it. Construction is for what purposes in this case? The construction in this case is for the operation of the highway. 17 years is for operation in this project. There is no reason why I should not fall under operation. It is not that I get paid on construction. My payment starts after construction on COD, commercial operation, and various other things. Now, if my lord comes to page 100 of the same paper book,
Same affidavit.
serial number 12, page 100.
Splitting, yes.
Serial number, actually my lord will start with serial number 2.
Section 5.
Yes, section 5. Construction services. Under that, serial number 3, 9954, construction services again. Then see the tenor. Construction services of building, construction services of single dwelling or multi-dwelling or multi-residential building. Is like I appoint a contractor, build a house for me. There is no operation maintenance there. Then kindly come to serial number 13. General construction services of highways, streets, roadways, railways and airfield, railways, bridges and tunnels. It's the general construction. No operation maintenance, etc. So if it was an EPC contractor that NHA had appointed,
It'll come under this.
he'll come under here.
Yes.
In fact, for the record,
Yes.
the petitioner, having succeeded as a concessioner,
Yes.
had appointed EPC contractors to construct. Those people who constructed for me are under 9954. They are not eligible to GST benefit. But I am different. That's the point. That's the distinction. So therefore, the submission therefore is that if a classification is only indicative, it cannot take a precedence. It cannot be the deciding factor.
Yes.
B. Even otherwise, what I do is not a simpliciter construction. It is far more than that. C. The classification does not have any reference in the preamble of the notification to make it as a condition precedent and a fatal thing. And my lord, I would like to now present a judgment of Supreme Court in the context of erstwhile regime, where the lordships found that the description will drive and not the HSN code. Otherwise, the Supreme Court said, otherwise the whole exemption will become meaningless.
Yes.
And the question I ask myself therefore is, if a myopic view as the revenue has taken that it is only available for, not available for construction, I shudder to think who will get covered in this notification. It is not that an EPC contractor or anybody else can get covered by the description. Nobody will get covered. So the whole notification will fall on its own weight. That judgment I would like to present, which is Jain Engineering.
You've got a compilation with judgments.
Yes, my lord, there's some judgments.
Serial number?
Serial number 10, page 148. My lord, citation is 187-32 ELT 3 Supreme Court. Jain Engineering Company versus Collector of Customs, Bombay.
Yes.
The only question that is involved in this appeal, preferred under section so of the Customs Act, is whether the appellant is entitled to the benefit of notification number 281, granting part exemption from payment of custom duty in respect of rod bushes and camshaft bushes imported by the appellant. Before we refer to the said notification, we may notice the provision of the heading 8406 and 8463 of the Customs Act, which are as follows. 8406, internal combustion piston engines. Well, notices that the word part is missing here. 8406, internal combustion piston engines. The para 3. The said notification 281 as amended from time to time reads as follows. Notification 281. Articles specified in column 2 of the table thereto, annexed and falling under chapter 8406. Kindly mark this word. Our notification does not even say falling under HSN 9964, but here it did say articles specified in column 2 of the table thereto and falling under heading 8406 are exempt from so much of that portion of duty of custom leviable thereon, which is specified in the first schedule to the Custom Tariff Act, as is in excess of the rate specified in the corresponding entry in column 3 of the said table. Now kindly see the second row. Internal combustion piston engines for industrial and agricultural tractors and power tillers and parts thereof, excluding those which are interchangeable for use with other motor vehicle. So the description made a reference to parts. But 8406, which was the condition precedent in this preamble, in the very previous page, my lord would have noticed 8406 does not make a reference to part. Revenue's contention is 8406 does not make a reference to part. It matters not whether the description meant. That was the controversy. Para 5. This is the finding of the Supreme Court. The notification grants exemption in part from payment of custom duty in respect of articles specified in column 2 of the table and falling on 8406. Heading 8406 referred to internal combustion piston engines. Para 2 of the column 2 of the said table annexed to notification, which is relevant for our purpose, not only refers to internal combustion engines but also parts thereof. Heading 8406 does not, however, contain or refer to the parts of internal combustion piston. It is submitted by the learned Additional Solicitor General that as heading 8406 does not refer to the parts of internal combustion piston engines, the appellant is not entitled to claim exemption for the bushes even if they are parts of such engine. Secondly, it is contended by him that even assuming that heading 8406 also contaminates parts of engine, such parts must also be part of the engine and not few parts. I'll skip that. Para 7 is the finding. The notification provides that articles specified in column 2 of the table falling under heading 8406 is exempt from payment of certain portion of custom duty. Para 2 of column 2 of table not only mentions internal combustion piston engines undoubtedly forming part of only subject matter of 8406, but it also mentioned the parts thereof, that is to say parts of such engines heading parts of such engine. Heading 8406 does not refer to parts of such. Non-mention of parts in heading 8406 has given rise to a controversy between the parties. It may be that the notification has been inartistically drafted. It is however clear that the notification not only intends to grant exemption to internal combustion piston but also to parts thereof. Intention of the legislature. When therefore the intention is clear and manifest, it will be unreasonable to take a narrow view of the notification and not to extend its benefit to the parts of the engine referred to in heading 8406. To accept the contention made on behalf of the respondents that as heading 8406 does not mention the parts, the notification inapplicable to the parts will be to amend the notification, which the courts will not do. In our opinion, therefore, the notification will apply to parts of engine mentioned is also. So, in a situation where the notification preamble made a reference to the classification, Supreme Court had gone one step further to say, look into the intent.
Enlarged it.
Enlarged it. And here, my notification does not make a reference to the chapter heading as I said. And the description, there is no quarrel with that. They don't say that I am not falling under the description. So, therefore, the submission is to articulate the fallacy number 1, that we do construction is erroneous, patently illegal, not borne out of facts, they themselves contradict it. Fallacy number 2, that SSA controls the notification is patently wrong by virtue of judgment of Supreme Court, and also the unless context to the otherwise, contrary, etc., and also the non-reference in the preamble. Fallacy number 3 is intent of the law was always to give benefit to this kind of project construction. Now, the intent of the law, what is also known as the contemporary expositio, is a very vital tool available to my lords. The judgments of the Supreme Court and this court also, the contemporary expositio is not binding, but certainly it helps in appreciating what the context was. In this case, the contemporary expositio was the agenda item of GST Council and the minutes of the meeting back then in 2017. If they want to change the rules of engagement, they are...
You want the court to look at the intent of when the notification is issued at a point of
at
time.
that point in time.
And whether the circular diluted everything.
Everything. And they did. As it turns out, they did. So when I'm actually launching my assault on the circular, I'll come to those points. But here I'm only on the merits of the patent illegality on the face of the record by the various authorities. Now, on contemporary expositio, the same volume compilation that I submitted, my lord, may kindly have page 152, serial number 11.
Yes.
National and Grillers Bank, page 152. What has that?
Yes.
Operative part may be had at page 157, para 5. May I read, my lord?
Yes.
We shall, however, assume in favour of the appellant that the meaning of section 146(2) of the Act is obscure, and that it is possible to interpret it as throwing the primary liability for payment of property tax upon the lessee who has constructed a building on the land. Even upon that assumption, we think that the view of the law expressed by the Bombay High Court in this case ought not to be interfered with. The reason is that in a case where the meaning of an enactment is obscure, the court may resort to contemporary construction. That is the construction which the authorities have put upon it by their usage and conduct for a long period of time. The principle applicable is optima legum interprets est constructu. In so-and-so case, in dealing with interpretation, etc., I will not get into all of that. Last line of that subparagraph, that is a very strong contemporary exposition of the meaning of the Act, so-and-so. They apply that. Then, para 6, just above that.
In
our opinion, the principle of contemporary expositio applies to the present case. The Act was passed in the 1888. There appears to be a practice followed by the Bombay Municipal Corporation for a long period of time of treating the land and the building constructed upon it as a single unit and charging the property tax upon the owner of the land in a case where the land is let for a period of less than 1 year to a tenant who has constructed the building, see so-and-so. So for 4 years you did nothing because you were bound by the GST Council's dicta. That was the contemporary expositio. Some somersault happens in the subsequent 2021 minutes of the meeting and you say what I did was wholly wrong. Suppression, fraud, collusion, misstatement, section 74. Thus, therefore, the relevance of contemporaries. There is another judgment in the same compilation, page 159. I will not read it out, I will just point out the paragraph because I have already read out the main thing. Page 159, Deshbandhu Gupta. What has that?
Yes.
Operative is at page 168. It may be para 9.
This is 1979.
Correct, ma'am.
Yes. Para 8.
Para 9.
Oh, sorry, para 9.
It may be stated that it was not disputed before us that these two documents which came into existence almost simultaneously with the issuance of the notification. And my replica here is that the minutes of the meeting agenda and notification, simultaneously it came about. It may be stated that it was not disputed before us that these two documents which came into existence almost simultaneously with the issuance of the notification could be looked at for finding out the true intention of the government in issuing the notification in question, particularly in regard to the manner in which the outstanding transactions were to be closed or liquidated. The principle of contemporary expositio, interpreting a statute or any other document by reference to the exposition it was received from contemporary authority, can be invoked through the same will not always be decisive of the question of construction, Maxwell so and so. In Crawford versus Crawford and statutory construction, I'll skip this part a lot. Now kindly come to the next page. That's a lot, this is all general law.
Yes.
Considerable weight, it is highly persuasive. This is the most important thing. In Balesha so and so, the principle which was reiterated by Mathura Mohan Saha was Mukherjee J. Das. It is well settled principle of interpretation. The courts in construing a statute will give much weight to the interpretation put upon it at the time of its enactment. And since by those whose duty it has been to construe, execute and apply it, I do not suggest for a moment that such interpretation has by means a controlling effect on the courts. Such interpretation may, if occasion arises, have to be disregarded or for cogent and pursuant reason, and in a clear case of error, court would without hesitation refuse to follow such construction. So that's the ambit, and therefore I rely heavily on the minutes of the first 2017 and the notification that came to be issued. Therefore, my lord, that is my submission insofar as the patent illegality is concerned. Now, the aspect, my lord, had asked me a question last time. This distinction between annuity toll, BOT toll and BOT annuity, did we tell them? My lord had asked me this question and I said yes, at the appropriate stage I will show that. I wanted to show that for my lord's consideration that this was told to them. If my lord comes to my rejoinder, which rejoinder is this? State rejoinder. Respond number 2. I have annexed my reply to show cause notice.
Where is that page?
Page 51.
Yes. 1st March 24.
1st March 24.
Yes.
Because sometime in December, my lords were pleased to dismiss our petition. We went to Supreme Court and then we came back. So 1st March 2024, then we filed a reply. Now kindly come to the very next page, page 52. I just read para 4 and 5. My lords are there?
Yes.
The road highway projects in India are classified as BOT, toll, BOT annuity, engineering procurement construction, EPC, and HAM, which is hybrid annuity model, and the toll operate and transfer model, TOT. So there are 4-5 kinds of model. EPC was one of them that I explained, other was toll and annuity. Under BOT model, the National State Highway Development Authority such as MORTH, NHI, etc., which is authority, grants to the concessionaire the concession rights to design, finance, build, operate and maintain the road at its own cost and to discharge various obligations such as regulate the entry and use of road, regulate traffic, prevent unauthorized access to road, prevent encroachment on road, etc. during the term of concession agreement, which enables the concessionaire to operate the road and provide the ultimate operation services by way of access to road during the concession period, and therefore thereafter transfer the same on completion of concession project. Under this model, the concessionaire brings their own fund along with the borrowed fund from banks, financial institutions to execute the project. The road becomes operational after completion of development of road. The concessionaires are given the right to collect toll during the operation period, starting from the date on which it becomes operational and ending on the date on which it is transferred to authority in order to recover the investment. Since in this model, the recovery of investment happens through toll collection in the operation period, it is commonly known as BOT toll model. The interest of private players in BOT toll model started to decrease gradually due to uncertainty about recovery of investment through the toll on account of traffic risks. Hence, in order to encourage and further participation from private players to speed up the infrastructure development in the country, the government slightly tweaked the BOT toll model to form BOT annuity model, wherein the project under development remains same as BOT toll, with the only change that the concessionaire recovers his investment in the form of annuity receivable from the authority in lieu of toll in order to eliminate the traffic risk. In other words, under BOT annuity projects, the rights obligation of the concessionaire and the services provided by the concessionaire remains the same as BOT toll projects. The only difference lies in the form of recovery of investment made by the concessionaire by way of annuity as against by way of toll. Hence, BOT annuity projects, annuity is paid in lieu of toll to concessionaire for providing same services as provided in BOT toll projects, services by way of access to road. The BOT annuity model is a PPP model for infrastructure projects, especially road projects, Under BOT annuity model, developer concessionaire builds the highways, operates it for a specified duration, discharges various obligations and transfers it back to the government. Government starts annuity payment to the concession after launch of the commercial operation. This attribute was declared to them in my reply. They chose to ignore it. Now, my lord, I also wish to place on record few public documents, and I'll only show the relevant paragraphs. First is from the Ministry of Road Transport, which amplifies what you have written in the reply to show cause notice. These are public documents, volume 7. Page 58. Let's see the first line, small font, Ministry of Road Transport and Highways.
58 years.
Yes, first line, Ministry of Road Transport and Highways. Posted on 12th March by Press Information Bureau, Delhi. Now, para 2, Public-Private Partnership Projects, PPP. Different types of PPP model are as under: BOT toll. Private developers, operators who invest in tollable highway projects are entitled to collect and retain toll revenue for the tenure of the project concession period. Responsibility for design and development of the project is vested with the concession under this mode. He is also responsible for operation and maintenance of O&M of the project for the entire concession period after it is developed and put to commercial operation. The tolls are prescribed by the authority on per vehicle, per kilometer basis for different types of vehicles. BOT annuity, which is where we fall. As in the case of BOT toll projects, responsibility for design, development and O&M of the project section for the entire concession period is vested with the concessionaire for the project. The concession is given annuity payments during the O&M period as per the provisions of the concession. Tolling rights and the O&M period vest with the employer after declaration of the commercial operation of the development section. So it's the same, just the change of methodology. Then kindly have page 61.
How much longer would you require, Mr. Ghosh?
Look, this part another 10 minutes, then the rest of the sections that I have.
Yes, by 1:15 can you complete arguments?
No, my lord, that may not be feasible.
Because we have respective single benches also to attend to. That's the only thing.
Very well, my lord. May I make a suggestion? Let me carry on till lunch, if that is 1:15. I can stay back today. If my lord permits me, I can complete the balance.
We don't have a bench tomorrow.
I'm requesting my lord can constitute one because that continuity.
Then that have to go to the master of the roster.
I leave it to my lord, whatever is convenient to my lord.
Tomorrow will not be possible, Mr. Ghosh.
Then my lord, day after. On 4th.
Thursday we can. 4th is a Friday. Friday. No, Friday will not be possible, so this bench won't be available.
Then 8th.
8th will be fine. Yes.
It will be fine. Then may I be permitted to continue till 1:15?
Yes.
Yes. How much time do we have? Yes. Very well. 45 minutes.
Then we'll have single bench at 2 o'clock. Yes.
Page 60.
Yes. Yes. Page 60.
Page 60.
Yes.
This is part of the CAG's report. Report number 36 of 2014. Page 60. The Lord has that?
Yes.
Now, kindly turn to page 64. Public-private partnership, clause 1.5.
Yes.
Under the PPP arrangement, two main modes of execution are followed by NHAI: BOT toll, BOT annuity.
Yes.
BOT toll, the concessionaire, i.e. the private partner, is responsible for finance, construct, operate and maintain the road such entrusted to them. He is entitled to collect and retain the toll collected during the concession period. And now I'll come to the next paragraph. In the case of BOT annuity mode, responsibility of construction, operation, finance and maintenance rests with the concessionaire, and the toll collection responsibility rests with the NHI. That's the difference. So all the documents, I will not trouble my lord with all of that.
All of them,
in my written submission,
they the same thing.
Absolutely they say the same thing, and that is what the sum and substance is. Therefore, to conclude on first part of my submission, the very finding of the authority that I do construction is erroneous.
That you do only construction.
That I do only construction is erroneous. B, facts on record, undisputed is I do far beyond that, and operation and maintenance is the heart of it, is the substantive part of that. C, the contemporaneous exposition also shows that intent was to cover such projects. D, 9967, 9954 matters not. If the intent of the law is very clear, the Supreme Court decision, and even otherwise the preamble to the notification makes no reference to 9954 or the classification as a precondition is only indicative.
Yes.
And the last submission is, the Karnataka High Court has taken a view that the position of the revenue that they are canvassing here and as was canvassed in the state of Karnataka, that it is for construction, will not be applicable to such annuity project, has been, the Karnataka High Court has taken a view that the circular is bad. It's to be quashed and the benefit was accorded. So there is one decision of the High Court under 226, subject to it has been appealed, no stay operates. It is that decision that I wanted to canvass at that point in time. That decision also is a reflection of the judicial thinking about the larger scheme of the whole thing. When we showed the decision to the lower authority, kindly see how it deals with it. Just to close this particular loop. Kindly have page 123, para 4.17
of your paper book.
Of the paper book. Yes.
$123.
Yes, 123.
Yes, 4.17.
4.17. In the reply dated 1/3/2024, the noticee quoted various appeals in different courts claiming that wide order dated 11/7/2022 in the case of DPJ Bidar Chincholi Karnataka case.
Yes.
Annuity Road Project Private Limited vs. Union of India, Honorable Karnataka High Court have declared the circular number so and so dated 17/6/2021 bad in law, as it had the overriding effect on notification 32 of 2017. The amendatory aspect will not. Dated 13/10/2017. However, the noticee here have failed to mention that in the same order, dated 11/7/2022, the Honorable High Court of Karnataka also held that nothing prevents the department from imposing GST on the consideration paid by the concessionaire, like the noticee on payment received by them by way of annuity, but that has to be done in the manner known to law. What the High Court was alluding to, what you have done is wrong. You can do that through a process known to law, not through the circular business by overriding a notification.
Yes.
They completely misread the conclusion of the Honorable High Court. And then para 4.19 is even more interesting. The noticee further failed to mention that none of these appeals, including the case of DPJ Bidar Chincholi Annuity Road, have attained finality, and all the appeals are still pending before the Honorable Court till date. So merely because an appeal is pending, he doesn't want to follow it. So therefore, he is leaving it to my lords to take a view, the correctness of the Karnataka High Court or otherwise. What the Karnataka High Court said, my lord will find at the judgment is in my paper book itself, page 532. Annexure 36, volume 2. What is that?
Yes. DPJ Bidar, yes. Yes.
Page 532.
Yes.
I'll skip all the factual attribute which I have already spoken about. I will come straight away to para 9. 9 to 14. Very short paragraphs. May I read, my lord?
Yes, please.
Though what is exempted is mentioned as service by way of access to road or bridge on payment of toll charges, the said toll charges collected as consideration by the concessionaire towards construction and maintenance of the road. In short, the entire consideration for construction and maintenance of the road by concession which is collected as toll expenses is exempt from GST from 1/7/2017 onwards. Annuity is paid to the concession in lieu of toll charges. GST Council in its 22nd meeting held on 16/10/2017 took note of the same and his entire toll charges were being exempted from GST has decided to recommend exemption to annuity also, which include the consideration received by the concessionaire, which is clear from the recordings in the minute book which is mentioned in the paragraph 4 supra. The said recording makes it clear that it recommended treating annuity on par with the toll charges. Para 11. Pursuant to the said meeting, the notification number 30 so and so dated 13/10/2017 have been issued by the respondent number 1, wherein services by way of access to road or bridge on payment of annuity has been exempted from GST and no GST was being collected on the entire annuity being paid to the concessionaire, which included construction towards construction as well as the services that they provide towards maintenance of the said road. The reading of the recommendation of GST Council as well as the notification issued makes it clear that respondent number 1 has treated the annuity being paid to the concession on par with toll which the concession are permitted to collect from road users, and both were exempt from GST. This is the conduct of the authority. Therefore, for reasons thereafter, for reason best known to it, GST Council has clarified that annuity paid as deferred payment for construction of road highways was not exempted from GST as toll or annuity in lieu of tolls are. According to the impugned circular dated 1/17/766/2021 by the annexure so to the petition has been issued. It is settled proposition of law that a circular which clarifies the notification cannot have effect of overruling the notification in the instant case, which has to be considered notification. In the instant case, what has to be considered is whether the impugned circular is in violation of notification number so and so dated 13/10/2017 or clarifies the said notification. As stated above, the deliberation of the GST Council in its meeting on 16/10/2017 and the notification issued pursuant to clearly exempted the entire annuity being paid to the petitioner towards construction and maintenance of the road. It cannot be construed to have not exempted the annuity deferred payments toward construction of road. The impugned circular has the effect of overriding the notification bearing number so and so dated 13/10/2017 and has to be held as bad in law. Nothing prevents respondent number 1 from imposing GST on the consideration paid to the concessionaires like the petitioner on payment received by them by way of annuity, but that has to be done in the manner known to law. He just picked up this line. That was the context was something else. In the instant case, respondent number 1 has issued the notification under section 11 of the CGST Act, section 6 of the Integrated Goods and Service Tax, exempting the consideration received by the concession from highway authorities as annuity from GST. The clarification issued is contrary to the said notification for reasons recorded above. If respondent number 1 is desirous of altering the same, it has to issue fresh notification amending its earlier notification, and they did that. December 2024, they did that. 2024, yes, they did that. That amended notification, I had shown it last time, and I'll let me show that again. Page 444. Page 444, volume 2.
Yes.
Lord, sees this notification dated 30th December 2022.
Yes.
At just before clause 2, there is a subclause 2, serial number 23A.
Yes.
Serial number 23A and the entries relating to shall be omitted. This notification shall come into effect with effect from 1st day of December or 1st day of January 2023. So the method known to law was this. After this date, do I claim an exemption? No, I don't. I can't. So the method known to law, the Karnataka High Court, that the prophecy
Yes.
is this.
Rectified.
Rectified. Whatever they wanted to have a change of heart, they can do that. They are sovereign. In matters of taxation, they can pick and choose who they want to give exemption. There is no equality. There is no estoppel. None of those things. Legitimate expectation. None of those things. So we are not even saying that. So therefore, they should have considered this judgment in the right spirit, and they have not done so.
Yes.
Now my second part of my submission is where I start. Aside of the fact that 17/6/2021 is amendatory, which the Karnataka High Court also endorses, it is fatal in terms of jurisdictional also. Because the scheme of the CGST Act says...
You mean the competency?
Competency. The scheme of the CGST Act says that if there is a notification issued by the central government granting an exemption and you want to clarify the scope, the clarity has to come within 1 year. Because there should not be any disruption. You can't, after 5 years, 10 years, come out with a clarification. And that is exactly what has happened after 4 years. And that power to issue clarification is with the central government, not with the CBUC. Because central government is the legislature, delegatee who is legislated, and power to clarify is therefore attended to the legislature or delegatee in that sense, not to an administrator. This is to ensure that there is no encroachment, separation of power. Administrative authorities cannot get into legislative aspect and so on and so forth. That's the whole fundamental, that you administrator, you cannot do administrative legislation. I may point, my lord, to section 11(3) of the CGST Act, which is at page 626, volume 2. (627), 626, last line.
Power to grant exemption.
Power to grant exemption from tax. Clause 1 is the power. Where the government is satisfied that it is necessary in public interest so to do, it may, on the recommendation of the council, by notification exempt, generally either absolutely or subject to such condition as may be specified therein, goods or services or both of any specified description from whole or any part of the tax leviable thereon, with effect from such date as may be specified in the said notification. So the notification was issued by the central government, no dispute there. Kindly see clause 3. The government may, if it considers necessary or expedient so to do, for the purpose of clarifying the scope or applicability of any notification issued under subsection 1 or order issued under subsection 2, insert an explanation in such notification or order as the case may be
Within 1 year.
Within 1 year of issue of the notification under subsection 1, and every such explanation shall have effect as if it had always been part of the first such notification or order as the case may be. Explanation: for the purpose of this section, where an exemption respect of any goods or services or both from the whole or part of the tax level has been granted absolutely, the registered person supplying such goods or services or both shall not collect the tax. We are not concerned with this. Now see who had issued this clarification. That clarification was issued, page 158.
Let's get 3.
The heading itself says CBIC 9 so and so Tax Research Unit Section CBEC. Not Ministry of, not the central government in that sense. And who is it addressed to? It is addressed to the Principal Chief Commissioners. A clarification is in REM. 11(3), notification is in REM. Clarification is also in REM. Here it is directed to their offices. Clearly an internal administrative document.
Yes.
And that too after 4 years. 2021. 17 notification gets clarified by 2021. So there is a competency issue also. As the circular is ultra vires section 11(3) of the very statute of which it is a creation of. Now, third fault in this circular. My lord, this is an aspect of levy of tax. The courts have consistently held a view, you cannot levy tax through an administrative circular. Because the circular is not law. Under Article 13, circular is not a law. If you choose to impose a tax, as the English judgments have also held and Supreme Court has endorsed, that you should be clearly within the net. No surmises, conjectures, no administrative fiats, none of those things. So this very golden thread of the scope of an administrative instruction has been violated here, because it is this circular which clearly takes an unequivocal view that you are taxable. You are not allowed, eligible to exemption is the sequitur of your being taxable. Now, the volume that I had submitted, volume 8, serial number 6 is Harvansh Lal, page 116. Page 116.
71
Yes. 1971 to SCC. Operative part, my lord, will find at page 118, para 6. It's a customs issue.
Para 8.
Para 6, page 118.
Question of.
This takes us to the question whether there is any liability to pay custom duty when someone sent goods from Goa to Bombay in 1962. No statute or statutory rule was placed before the court to show that any custom duty has been imposed on the goods transported from Goa to other parts of India after December 20, 1961. The only witness who spoke about the liability to pay custom duties in the goods in question is PW 56 Sheikh, the Deputy Superintendent of Central Excise. According to him, custom duty on those articles was leviable because of certain administrative instructions. But he refused to place those administrative instructions before the court. He claimed privilege on the ground that they are confidential documents, a strange claim. Stranger still is that the trial court appears to have accepted that plea. No tax or duty can be levied or collected except by authority of law. Hence, no custom duty was leviable on the basis of an administrative instruction.
Yes.
And in the same way, in the next judgment, in the same volume, page 1, Punit Rai is a more recent decision of 2003. 3 learned judges. Well, has that page 1?
Yes.
Punit Rai. Operative part is at page 19. This is not a tax judgment, but nonetheless on the jurisprudence, para 42.
Yes.
The said circular letter has not been issued by the state in exercise of power under Article 162 of the Constitution of India. It is not stated therein that the decision was taken by the cabinet or any authority authorized in this behalf in terms of Article 166(3) of the Constitution of India. It is tried that a circular letter being an administrative instruction is not law within the meaning of Article 13 of the Constitution.
Yes.
The fifth fault line in the circular. Now, the purpose of circular is for administrative convenience, uniformity in approach. Courts have in repeated cases held, through a circular you cannot predetermine an adjudicatory fact, whether you are exempt or not, whether you are taxable or not. You cannot, because that is for the adjudicating authority to take a view. Now kindly see what has happened here. The adjudicating authority is heavily influenced by this circular, and he quotes the circular in my adjudication order. Because being an officer in the hierarchy, an additional commissioner, assistant commissioner, whoever the commissioner is, will always be subservient to the board. Their patronage, faith and fidelity is to their administrative masters and not necessarily to the courts.
It's a question of towing the line.
Towing the line.
There's nothing else.
Nothing else. Yeah. And this is what the Supreme Court had deprecated. That don't foreclose a person's right to adjudicate or to ventilate what is taxable, what is covered, what is not covered. I place one judgment of Supreme Court and a few High Court decisions on this very vital aspect. But before that, if kindly see sections, page 635 of my paper, of my writ petition, volume 2. Section 168 of the CGST Act I have reproduced, which is the source of power for issuance of administrative circulars. The board may, are there? Yes. Board may, if it considers it necessary or expedient so to do for the purpose of uniformity in the implementation of this Act, issue such orders, instructions or directions to the central tax officers as it may deem fit, and thereupon all such officers and all other persons employed in the implementation of this Act shall observe and follow such orders, instructions or directions. This is the towing the line. But towing the line qua what? Second line, for the purpose of uniformity in the implementation of this Act. The word uniformity in implementation of the Act is different and distinct from saying what is the scope of a notification or the notification content has to be completely overridden. So implementation Act would be okay, if you want to file a registration application, let it all be here, sent here. Okay, if there is any trouble that you are finding in the portal, this is how you have to do. So on and so forth. Those are all administrative things. Nothing touching upon substantive aspect of which the legislature is only the supreme commander. Now this aspect, the Supreme Court, volume 6, it's a very short judgment, but a very beautiful way the Supreme Court has put up. Because similar section 168 was there under the Customs Act and the Central Excise Act. Page 45.
Yes.
Page 45. Union of India and others versus Karvi Stock Broking Limited.
Very short judgment.
Very short judgment. 2 paragraphs. Lord has that?
Yes.
Yes. The undisputed facts are that the Government of India had issued notification number so-and-so service tax whereby it exempted the business auxiliary services provided by the commission agent from the service tax leviable thereon under subsection 2 of section 67 of the Finance Act. Thereafter, the circular dated 5/11/2003 was issued, in which it stated that having regard to some doubts that have arisen regarding application of service tax on the applicability of mutual fund distribution, it was clarified that the commission received by distributors on mutual fund distribution would be liable to service tax, as it would not fall within the expression business auxiliary services. Very similar to what they have done here also. This circular dated 5/11/2003 has been set aside by the High Court in the impugned judgment on the ground that it amounts to foreclosing discretion or judgment that may be exercised by the quasi-judicial authority while deciding a particular list under present circumstances. The High Court referred to the provisions of section 37B of the Central Excise Act, which categorically state that such kind of circulars cannot be issued. We thus do not find any error in the impugned judgment. This appeal is accordingly dismissed. This is the crux. That adjudicatory facts you cannot interfere with. And that is exactly what has happened, that the concerned commissioner has got influenced. And my lord, I want to also point out that section 168 does not even have a protection as section 37B used to have. Section 37B used to say that the circulars will not bind the Commission of Appeals. 168 does not have that protection. As I read out 168,
Yes.
does not have the protection. 37B has that protection. In the same volume, if my lord sees page 24, I want to show 37B. Para 91, this except of the judgment. Page 24.
This is very small print.
This is small.
Yes.
Para 24, blood. Para 91.
Yes.
Now we
91 and page 25.
right. Now we propose to examine. My lord has that.
Yes.
Now we propose to examine the other main issue involved in this case, whether in the guise of the circular the respondents have in fact brought out a revenue legislation, which is what the contention was there also, for imposing excise duty. The other obvious question which arises for adjudication is whether, according to the ambit and scope of 37B, excise duty can be imposed. In order to properly comprehend 37B of the Act, it is necessary to reproduce 37B as it reads as under. Instruction to Central Excise Officers. The Central Board of Excise and Customs, constituted under the CB's Central Board of Revenue Act, may, if it considers necessary or expedient so to do for purpose of uniformity in classification of excise goods or with effect or with respect to levy of duty or excise on such goods, issue such orders, instruction, direction to Central Excise Office as it may deem fit, and such officers and other person employed in the execution of the Act shall observe and follow such orders, instruction, direction of the said board, provided that no such order, instruction, direction shall be issued so as to require any Central Excise Officers to make a particular assessment or to dispose of a particular matter, or so as to interfere with the discretion of the Commissioner of Central Excise Appeals in case of appellate functions. This proviso is missing in 168.
Yes.
So therefore, what it does is, this circular goes and trenches upon the independence of the judicial act or the quasi-judicial authorities, which the Supreme Court had deprecated, and there are several other High Court decisions. I will not trouble my lord on that. In my written submission I will put. Be it noted that whenever circulars have tried to interdict a notification or a law,
They've been set aside.
they have been quashed and held to be bad in law. And even in all of those cases in the pre-GST era, notwithstanding the protection that they had of the proviso, which said that it will not be influenced, it will not influence an adjudicator or an appellate authority. Here we are in a situation where there is no protection whatsoever. So for till cows come home, I will get stuck, and I have got stuck, as the case is. So therefore, I submit that this circular is bad on that count as well, as it has travelled beyond 168, and also it has impinged and interdicted on adjudicatory fact. Lastly, on this point, my lord, there is a judgment of Supreme Court. I'll just explain the context. Assuming for any moment what they say is correct, Supreme Court had held that whenever there is an adverse circular which seeks to take away what may have been given, it will only have a prospective effect.
No, that's the next point. Yes.
Because fairness in matters of especially indirect taxation, because if I knew it was taxable, I would have recovered it. After 4 years, you can't tell me. So the judgment in that regard is Suchitra component, volume 3. Can you just pass on volume 3? One judgment and I'm done with this particular aspect.
Serial number?
What is the serial number? Serial number 9.
Serial number 9.
Page 47. Lord has that?
Yes.
Page 47, para 2. That's the paragraph I wish to rely upon. We have heard Mr. So-and-so learned counsel for the appellant and Mr. So-and-so learned senior counsel for the respondent. We have perused the orders passed by the learned authorities and also of the tribunal. The point raised by the learned counsel for the appellant is covered by the recent judgment of this court in CC Mysore Electrical Industries. In the said judgment, the court held that a beneficial circular has to be applied retrospectively, while an oppressive circular has to be applied prospectively. Thus, when a circular is against the SSC, they have the right to claim enforcement of the same prospective. So my respectful submission is 2021 onwards at best. Certainly not prior to that, assuming circular is held to be good, and all my submissions herein before on the validity, competency, etc. is not accepted by this court. As a last resort, this is my safety net that I wish to source. So this therefore contains my argument on circulars, or the circular, the validity of that. The third tranche was something that will require me to labor a bit. So
then we will conclude for today.
I wish to conclude, because that is the substantive, because that goes to the another new dimension.
Yes.
To say whether DRI or DGCI, intelligence authorities, are proper officer under the GST Act. There are two kinds of officers. Officers of the state and center cadre, who are known as the central tax officers, who have a jurisdiction. They are located in the state of Assam, state of Meghalaya, UP, etc., etc., or the central tax officer in the same jurisdiction. Those are called the range authorities, authorities in the range. Superintendent, additional commissioner, assistant commissioner, they all come in the rank and file. Then there is another body called the investigating authority, which is the DGCI, Director General of Revenue Intelligence is for Customs, DRI, and Director General for Goods and Service Taxes. So they have a national footprint. Now they are, if I were to use a word, smart word, they are sleuths. They identify industry specific issues across the country because commonality of trend is there. So something that they caught in Karnataka, they can try and implement in Madhya Pradesh also, if provided the same trail is there, and they are very effective. This show cause notice was issued by the officers of DGCI, Director General of Goods and Service Tax Intelligence. The question is, under section 74, which has been invoked, the power to issue show cause notice is with the proper officer. The question is whether DGCI is the proper officer or not. There is a notification under the GST Act which the DGCI uses to say that I am a proper officer. If that notification is good in law, then they have the jurisdiction. If the notification is not good in law,
It goes.
then everything goes. Now, that's a very fundamental thing. It's got nothing to do with toll versus annuity, and therefore I'll need some time to explain.
We'll hear you.
Eighth
Mr.
block.
Ghosh, can I complete this? We'll continue with arguments on 8th.
Eight.
Is that all right? Really?
Eight, my lords are posting on 8th. I'm sorry.
Otherwise, Mr. Ghosh, because he just informed me that we have other fixed matters on the 8th, whether we take it later in the week.
Lord, 11th? 11th?
11th is Thursday.
No, it's a Friday, Lord. My difficulty is that, because of 2 dates that are chosen, I have other high courts to.
Yeah, the thing
Maneuver.
is that we are constricted also.
But since it is fresh in the mind, I'll take my chances on 8th. Let it come on.
But the thing is that you need, you see, what we want to give you enough time so we can conclude.
I appreciate.
You can hear the,
I appreciate,
you know,
I
Dr.
appreciate.
Mozika also. That's the only thing. And while still fresh in our minds,
The Milords are sitting only on Tuesdays. Is that
Tuesday and Thursday.
Thursdays? No, Tata Steel, Calcutta High Court. Tuesdays, next Tuesdays. Lord, 15th Tuesday.
Yes.
Well, 15th I have some difficulty. I'll
I
not
was
be.
waiting for that. Yes, anyway.
Lord, keep it on 8th.
Councils also
Because,
have
because that entire week I'll not be.
Then we'll keep it on 22nd.
Lord,
8th I'm fine.
8th, which is how other fixed matters.
8th or 10th.
Lord, 22nd I am conflicted. I'm in Madras High Court at a partnered matter. But that's the difficulty that I'm facing.
Senior councils, that's why we are here only. We try to accommodate as
Lord,
much as possible.
Could it be, let me take my chance on 8th.
8th will be because we have other progressive, there's no partnered matters are there.
I understand.
So that's the thing.
Why is it required?
8th to 10th.
So we can't have, like, have you come here and just,
No, I
again,
understand,
like, have
I
a
understand.
truncated kind of a.
17th, my lord, then 17th.
17th is a holiday, I think.
You can continue. 8th and 10th I think we can finish.
No, 8th, we have other this progressive, other partnered matter. And the problem is we have to attend a single benches also, so we
I
have.
understand, my lord. When, what dates we
We
have?
have to tomorrow for Thursday.
The Thursday,
This Thursday.
but Thursday I'm in Punjab and Haryana. This is some partnered, all partnered.
24th,
No, my lord. I'm so sorry, my lord.
can you just inform Dr. Mozika and Ajus, then they can give a date.
Very well, my lord. I don't want to hold out. May I take my chances on 8th, my lord?
8th, you see, we have other partnered matters, that's the only
Right.
problem, and they'll take proceedings then.
Then may not, could my lord constitute the bench tomorrow? I can stay
So
back.
tomorrow will be difficult because there's not a
Oh,
criminal
he's-
bench
okay.
which my brother has to
Then
be.
may I request on Friday 11th?
11th?
11th I have difficulty.
11th Friday.
But since I will continue, his junior can be there on 11th if that is convenient.
11th we have to make a request for bench
But 11th.
constitution is the only thing. But this bench normally is not available.
I understand. I'm therefore requesting that
What
my
you
lord may
have to-
request.
Our request is just limited to Tuesdays and You can tell your junior Tuesdays and Thursdays, any date.
The 15th, he is not available. I was available.
15th, you can complete arguments then.
Yes, then 15th, let me complete my
You complete
argument.
arguments,
Yes,
then take down notes.
very well.
Yes. At least you can watch you on YouTube also.
Yeah, he can watch. 15th then, my lord.
15th.
15th.
Then
I'm so
complete
obliged.
Argument 15th, then we'll
Yes.
then replies after. Yes.
I'm so obliged.
Yes.
Any mention?
May it please
Yes.
your lordship. Your lordship, I beg to mention item number 29, your lordship. The conducting counsel is currently not available, your lordship.
No objections, Your Lordship.
Okay, 1 week, 2 weeks. 2 weeks, sir. Yes.
Similar prayer for item number 19, your lordship.
Ling Tariang,
Yes, your lordship.
who's for the petitioner?
They were outside, your lordship. Ms. Z. I saw.
You've informed them?
Not yet, I've not.
Inform them.
I'll inform them, your lordship. Ms. Zeti Nonkanri is handling the matter. She's currently not available.
Inform them, then mention it. Ling Tariang, Mr.
Yes,
Marpanze. Yes, you have objection, they're seeking adjournment.
No objection.
After 1 week, 2 weeks.
Any date, your lordship. After a week also.
Every 2 weeks, sir.
Okay, yes.
Thank you.
Obliged, lordship.
May I please, your lordship? I beg to mention item 27 for adjournment, lordship. I've already
Prakash
taken. No, your lordship. Vasudevan. Vasudevan, your lordship. For 1 week, your lordship.
Okay, yes.
Obliged, your lordship.
Was it 26 also as praying sometime?
Vikash Kumar.
Lord, this is that hypertension in young matter, my lord. That hypertension in young, my lord. Recruitment, my lord.
Hypertension and?
Young.
Oh!
Young. Next week, my lord.
1 week.
Yes, my lord.
Yes.
May it please your lordship, I'd like to make a joint mention of item number 22.
What do you mean by joint mention?
Your Honor, we've
You got
agreed.
time also?
Yes,
Yes,
Your
Your
Honor.
Honor.
You have 2 weeks.
Salio Gachana.
May it please your lordship. Your lordship, I beg to mention item number 23, your lordship. I pray for 2 weeks' time, your lordship.
No objection, Your Lordship.
Yes.
Similar prayer for item number 28, your lordship.
Yes.
Highly obliged.
No objection, yes, Your Lordship.
Whenever we hear the word objection, only we hear from PT Sangma and from 1 or 2 lawyers. Others, yes.
Highly obliged.
Highly obliged, Your Lordship.
May I please, lordship. Lordship, I beg to mention item number 24. The conducting counsel is not available
Who,
today.
Mr.
No, your lordship. Double AG.
Who double AG?
Ma'am Yangi.
No objection, Lordship.
2 weeks, okay. No urgency?
It's a regularization matter, Lordship.
Yes.
Much.
Most obliged, Lordship.
Supplementary list, item number 1.
Again, my lord, land acquisition matters.
Only, what's the other cases?
Lordship,
It's listed tomorrow, my lord. It is listed.
Before Lordship comes to the matter, Lordship, I'd like to address one issue, Lordship, which we were facing at the time of filing this petition, Lordship. May I kindly have a look at this letter?
What has happened?
Lordship, this is the letter which came from the office of the NHIDCL, Lordship, and they're asking for prior service to serve them before we file, Lordship. And the registry are not accepting the petitions without serving them at their regional office. So, Lordship, this is the difficulty which we are facing. So, I just would like to bring to the notice of this.
Who's appearing? Who appeared? Mr. Dr. Mozika?
NHIDCL.
Yes, so the counsels are there, Dr. Mozika and Mr. Shankar Pandey, Lordship.
The notice we should make.
No, see.
Because registry are not accepting,
To streamline the
Lordship.
process, avoids the occurrence. Humbly pray the good office issues is address the joint registrar to the counsel for the claimant's petition route.
Yes.
Any petition applicant received to the office, not directly to the counsel appearance department.
Because the High Court rules doesn't say that we have to serve them in their departments, Lordship.
Yes,
Serving to the services.
You serve
I know.
the state.
We have
The
already
process,
but
my lord,
the process,
in
the
these
registry
matters-
are not accepting.
Process is what's up. How can we file it? Suppose the petition is accepted
No,
or
what-
notice was not to be issued by the court.
No, my
Suppose
lord.
the court doesn't deem it fit to issue notice.
No, my lord, what the process is that when they do in advance copy, they send it in Delhi High Court, in other by post also they send it, and that is what they and affects it.
So they want to put him so they can have a response at the time the case comes up, so
yes,
no interim orders are passed.
Yes, my lord. That is the object.
So only one thing is that before filing you serve copy on HIDL.
They're not accepting law, sir.
Not accepting.
No, the councils are not accepting law, sir.
You just resolve it with them first.
That's
Just
the
take
issue,
down.
Lord, sir.
I will not pass any orders. Just give a copy to Dr. Mozika.
Yes,
say
I've
that
already given.
just that they should serve upon your juniors. That amounts to like prior notice. Yes.
And that is exactly what the High Court rules is saying.
They want to do endorsement themselves.
There are only two counsels here.
Yes.
Well, notice we should, but in other cases, notice that it is issued. They'll do the endorsement.
There's one why, but this has come today, correct?
Lordship, what we have to do is we have to scan the entire petition and send it through via mail, Lordship. So that is also time consuming and it's difficulty, Lordship. So
I'll take it up registry. Yes, this is matter tomorrow also with the other matters.
Yes, Lordship.
Yeah, the other matter is, my lord, 475 of 2024, my lord.
Lordship.
8 petition 4.
474, Lordship.
Petition
474 of lines also.
Item number 2.
My lord, in this case, about 3 bighas of my land, my lord, was taken over by the National Highways, earmarked by the PWD, my lord, for construction of the highways, my lord, which I never knew that they've encroached. Now only in the month of somewhere August 2024, because this is pertaining to North Garo Hills, my lord, we have shifted to Shillong for the purpose of our children's education. So we left our land there. So now August, when we went back there, we came to learn that around 3 bighas, we have taken measurements and everything. So after that, my lord, we have filed representations to the chief engineer, my lord, stating that you have taken about 3 bighas of our land, my lord. And while pursuing, we have written to the deputy commissioner also, my lord, please to rectify this. We are not saying that don't take our land, my lord. For the development, we are ready to part with our land.
Give us money.
But at least go for a proper procedure. Go for a proper procedure in acquiring my land. This is what I am saying, my lord. So now, while pending all these matters, my lord, January they have issued one notification saying that by giving a notice, we're saying that those landowners whose lands has been destroyed or damaged owing to the construction of the highways are called for a public meeting. So now my name is there. About 5 lakhs rupees has been awarded towards my name, my lord. So I am saying that when I am already pursuing my remedies here, you are not following the due process of law in acquiring, and out of a sudden it comes out and says that my land has been destroyed, you come and collect the money. The notification is at page 42, my lord. Page 42, annexure 9. And this is in Garo, my lord. The translated copy is at page 44, my lord. So may I just read the information, my lord? Regarding the damage caused to the land due to the construction of National Highway number 217 and the payment of the compensation those affected, my lord. This is to inform all landowners, those whose land is affected by the construction of National Highway, so and so, my lord. So then annexure A, my lord. They've given annexure A. Annexure A is page 46, my lord. Serial number 5, Dipagarat. That's my land, my lord. So even this notice was not made aware to me prior to the date of hearing. In fact, I have requested to reschedule the public hearing, my lord.
When they've scheduled it?
No date has been fixed. Page 47 is my request for reschedule of the hearing, my lord. Page 47 is my request, my lord. Rescheduling of public hearing.
No, when is it? Has it been concluded?
No.
My lord, the page 44, what my friend has read, my lord, if your lordship will kindly see just now I have also noticed, my lord,
yes,
that land has been acquired according to Gazette of India notification dated NH 1956 and so under 3D of NH Act 1956, and details are as published. So the land has already been acquired under the
Emergency provision, correct?
yes, under the National Highway Authority Act, my lord. So
This is National Highways Act.
Yes, yes. National Highways.
National Highways
So
Act.
National
So
Highway.
my grievance
And then
is-
what he says,
National Highways Act.
for payment of compensation to the affected landowners and property owners, funds have been allotted to Deputy Commissioner. All landowners, those whose land is affected, can collect the compensation amount from DC office. So the details will be there in the, and there is a procedure of arbitration, my lord, under the National Highway Act. Give me the National Highway Act.
It's under 3A.
Yes, my lord, there is a arbitration proceeding which, so I don't know.
Hearing objection 3C.
Yes, my
Yes,
lord.
3C, then 3D, declaration of acquisition, my lord.
Already declared acquisition.
Yes, my lord.
Very separate reform. Yes.
So therefore, what my friend is asking from this honorable court is he has to he has the remedy under the National Highway Act only.
Under 3G.
3G, determination of
compensation.
as compensation, my lord. So this is what I have been asking them also, my lord. Let us follow the due process of law. I am not saying that I will not give you my land, but at least follow the due process of the law, my lord. And that's my prayer also
See, the
precisely.
thing is that what they've done
Yes.
3G3
Yes.
says before proceeding to determine the amount,
Yes.
public notice be given. Correct?
Yes. Yes.
Publish in 2 local papers, vernacular language,
Yes,
Yes.
madam.
so and so.
Yes.
So particular the land,
Yes.
if the amount, see, that you have recourse to 3G5.
Yes.
If the amount determined by the competent authority under subsection 1
Is not acceptable.
The party amount shall be by arbitrator to appoint national government.
Yes. Now, the problem, the grievance here is, my lord. What about my 3 bighas of land which has already been? Because this is a flowing, my lord. They are silent completely
See,
on
we're
the
not
3
going to go
bighas.
into disputed facts now whether 3 bighas,
no,
2 bighas.
exactly, my
But
lord.
the thing is that
Therefore,
under 3A has been taken over.
So
correct? There's a power of central government to
yes,
take over
yes,
land.
yes.
Now they say anybody who has any grievance,
Yes.
they are the following.
They need to
sections
address.
will give you yes. How
Yeah,
to
they need to address,
And
my
if
lord.
you are not satisfied with compensation,
Yes,
you have
yes.
5 lakhs giving you. So they've assessed 5 lakhs.
Yes.
Now we have a problem. You go for arbitration like a reference.
My lord, I have
Under
already given a reference also, my lord. I have requested for a reference, of course, under section
Reference can't be under
64.
section 18 because this acquisition is under
Section
under National
National Highways Act, my lord,
Yes.
of course, my lord.
So this act, this my
So
friend has
at least, my lord, what my grievance
you
is
want
that
now?
no, at least they address to my
You
grievances, my
want
lord. This is
your
yes.
acquisition to be under that 2013
My lord,
Act.
2000 no, it doesn't matter whether
Maximum
2000
compensation.
no, it doesn't matter 2013 or
Once it goes
national
arbitrator, Mr.
nation-
Yogan, you'll get the same thing.
Same
because
thing.
they will value it, on that.
my lord, my grievance before my lord is, as I made myself very clear, that you take my land, no problem. I'm ready to, for the development of Garo Hills, I'm ready to do that.
They have
But
already
at least
taken.
address my grievances. This is my
They've asked a public hearing. Compensation been fixed. You have recourse of 35G.
35G.
my lord,
And
more do you want?
then NH National Highway Authority is a necessary party in this matter.
Yes.
And you have not made National Highway Authority as party to this case.
3F.
3F.
Section
Yes.
3GF.
yes.
Yes, you take recourse to that.
My lord, then I'll withdraw with alternative remedy, my lord.
Yes, yes.
Yes,
you
my lord.
make immediately.
My lord.
Stop this Mr. P. Yogan submits that on reapplication of the matter. He may be allowed to withdraw the instant writ application and to take recourse to alternate remedy as provided in National Highways Act 1956. Correct?
Yes, my lord.
Only matters stands close and on withdrawal with liberty as prayed. You'll get much more on 2013 if you need to present your case.
Take this.
Obliged.
Item number 1.
Who's for petitioner? Yes?
May it please your lordship, I'm for the petitioner.
Yes.
Your lordship, since the main conducting counsel isn't doing well, so I would like to humbly pray for some
This is a
time.
matter, we post it together, there's not a connected matter challenging the resolution.
Lordship.
After the Supreme Court order.
Lordship.
When? After 2
probably-
weeks. Yes.
Okay.
On the request of the counsel of the petitioner, matter stands over for 2 weeks. Let the matter stand over for 2 weeks. Yes.
Item number 2.
Where's the petitioner?
It's not around.
None appears for the petition is after 1 week. Yes. Yes.
Item number 3.
Yes.
I'm for respondent 1, my lord, the pollution board here.
Dr. Mosika, yes, you want to find affidavit on behalf of respondent number 2?
What instruction I have with my lord? It's only about the certificate issued by the rubber board.
By the rubber board?
And that is at page 87 of the report. So we stand by this, my lord. That's the only instruction I have.
Fix it for hearing, my lord.
Yes, Dr. Mosika submits that the only instruction is, the only ground, 87 you said?
Page 87.
Yes, Dr. Mosika, the number 2 submits no affidavit before coming from the respondents and has placed reliance on the certificate issued by the rubber board dated 28/8/2024, next annexure 16 petition. Next, in these circumstances, let the matter be set for hearing on so and so is.
Item number 4.
Yes, Mr. Guru.
Report on private respondent.
Number 2 receive.
Yes, Lordship, we have already filed for service affidavit for respondent number 2.
Today, my lord.
Today,
Your Lordship.
It has not come. It has not appeared yet. You're Mr. Idhar.
Dis Imlia.
Dis Imyong.
Dis Imlia, Your Lordship.
Dis
Imlia.
Was Imli, sorry. Dis Imli submits that service has since been filed. So the CMT have to come and record. So lists the matter after 2 weeks for appearance of respondent number 2.
Item number 5.
Yes.
Lords, I have received a copy of the objection filed by my learned friend now, my lords, at 1:15. We've been served with a copy.
My lord, review petition.
Whatever it is, my lords.
Review, what objections?
My lords had directed, my lords, that they file an objection on the last
Yes,
date.
objection, but the thing is that
my lords.
And already appeals have been preferred, my lord.
You already had
Appeals, and today it was listed also.
No, my lords, that's
and today it was listed
No,
also.
if I may finish.
It was listed also.
My lords, if I may finish.
It was
Your
listed
lordships may
also.
have my lords may have a copy of the matters that are listed before the division bench, my lords. Pioneer Carbide, who is the petitioner before your lordships, has not preferred any review.
Burney Hart has preferred, my lord.
Burney Hart is the second matter, my lords. That is not the
Burney
core
Hart
issue.
and Pioneer was part of Burney Hart, my lord.
Pioneer is not a question of Burney Hart.
Please, sir.
Well, we can't do this.
See, Mr. Paul, how can you expect to maintain? You can't sustain an appeal and review same time.
No, my lords. Pioneer is a different matter. My lords would recollect what had happened is originally Burney Hart come had.
You file appeals and you withdraw the.
No, my lords. In this, your lordships, as a matter of fact, the first query that had fallen for my lords when we had moved this matter is this matter not challenged an appeal? I said some others have preferred an appeal. Insofar as Pioneer is concerned, my lords, they have not preferred an appeal.
But just now, Advocate General said that.
My lords may have the cause list.
My lord, kindly see because
my lords may have the cause list.
We don't have the
your lordship. Burney Hart is review petitioner before your lordship, and Burney Hart has filed the appeal.
Burney Hart.
Yes, your lordship, kindly see.
My lords would recollect there.
Yes, I am coming one by one. Let me now.
If my friend wants to, no, if it is an abuse of the process of law, my lords, you don't file an objection at 1:15 and expect me to argue a matter at 2 o'clock.
Review itself is not maintainable, my lord.
Very well, my lords, may hear us on that.
Yes.
No, Mr. Paul, the only concern of this court.
Bernie Hart, if you
Well,
will see.
Please pipe down. The only concern of the court is that if you already filed an appeal.
My lords, may kindly see the cause list. My lords, my lords, may kindly take my My lords, may kindly take my statement on record. Pioneer Carbide has not preferred an appeal.
What about Bernie Hart?
I'm sorry, my lords.
Next item is Bernie Hart.
My lords, Bernie Hart, because there are two issues. Your lordships would recollect, Bernie Hart had come before your lordships at the first point of time with regard only to that, my lords, power of the commission. For recall, not recall. That was the first matter, my lords, which your lordships treated as the lead matter. Thereafter, my lords, the subsequent writ petitions came where they were challenging my lords, the question of retrospective effect. And then Mr. Tiwari's matter came in, my lords, where both these two issues were a simultaneous issue. So therefore, my lords, I cannot, my lords, also prefer an appeal and also an review. I am aware of that. Which is why, my lords, when the matter came up before the division bench today and my learned friend was available there, I said, my lords, we've made a categorical statement that reviews have been preferred. I have made a statement. I am the petitioner, so I will make a statement. Reviews have been filed. And, my lords, these matters are coming up today. That's why these appeals have been deferred to the 10th. I am making a simple prayer before your lordships today. I have been served with a copy of this so-called objection, my lords, at 1:15. My lords may grant me 3 days' time. I will file a reply. Your lordships will hear me on the day, and whatever objections either party wants to take, your lordships will then decide the matter.
Review is a very constitutional. The only thing is seeking is clarification.
I am, my lords, on that issue. Which is why I am saying.
If you already gone appeal, so let that.
My lords, appeal is on a different footing altogether. They have no connection.
It is tomorrow.
My lords, may grant me at least a day's time. My lords, I'll have to prepare them. Let's go have it on. Today is the
Thursday.
Thursday.
Let it be on Friday, my lords.
Friday is
Thursday.
Oh, my lords had expressed some difficulty. Thursday is okay. Because I would have to.
Mr. Paul submits that the objections is filed. Has just been filed and copy served. He prays the matter be listed after tomorrow. Praise the obvious.
Grateful.
I had in the first instance.
Really, I mean, if appeal has been filed, I mean, we can't cloud the issue, and you can't.
And Pioneer was part of Bernie Hart also, my lord. Pioneer is.
I can make any statement off the cuff. First, I say I've preferred an appeal. Then, when I point out appeal is not preferred, now I'm saying I'm part of Bernie Hart.
This is abuse, sheer abuse of the process.
Everything is abuse, my lords. My lords, when my learned friend stands, everything is an abuse.
Item 7. 7.
Yes, PT Sangma.
Lordship, I just need to get an instruction. They have filed the affidavit. They stated that there is process under.
You won't file the gender. You close the matter.
No, Lordship, just get an instruction whether they have admitted. They have filed that they are processing.
What have they said in affidavit?
They said that they have initiated for regularization. That's the thing. But
initiated
to regularize, because there was a direction from this court to regularize the service. Yes, for contempt.
Mr. PT Sangma prays allowed 1 week's time to obtain instructions. Yes.
Lordship.
Otherwise, we'll close it. Yes.
Yes, on the next day, Lordship. After getting instruction.
Much obliged, Lordship.
Much obliged, Lordship.
Item number 8.
Yes, after 1 week. 2 weeks.
Much obliged, Lordship.
If it may please your lordship, I pray for a week's time to file the rejoinder against the affidavit filed by the private respondent, respondent number 5.
You filed to 3 and 4. Yes.
Your lordship, we filed the rejoinder. The private respondent.
3 and 4 we have filed.
I'm the promoter.
Mr.
Promotee.
I'm the
1 and 2.
promotee.
1 and 2. You file affidavits.
We are not filing your lordship.
Actually, sorry, this is a very short. Just show the. What is your?
I'll bring the records, my lord. There are certain things, my lord. We were, my lord, in 2012. There were, my lord, there was some provision for restructuring the municipal, my lord, the post. So therefore, my lord, that is still pending with the government. Therefore,
charter of duties also.
No, my lord. I'll bring the records, my lord. Your lordships can go through
Because
the records.
municipality is a technical department.
Yes, my lord. I'll bring the record during the hearing.
The same person who goes and evicts hawkers, the same, he goes and does
No,
the pipeline.
my lord.
What kind of duty is that? So, yes, MS Teen Kutunga prays for how much time?
1 week's time, your lordship.
To file the joint out after file by respond number 5.
Your lordship, I'm praying for extension of the interim orders.
The interim orders of any shall continue till the next date. Yes.
Highly obliged, your lordship.
Item number 9.
9 is the
Your Lordship, is a contempt
contempt,
petition.
my lord. But we have rectified
What's the contempt? What is the contempt?
contempt of the interim orders, my lord. She was, my lord, paid salary at the higher pay. So there was a mistake by the accounts department, my lord. So we have rectified that, my lord.
Well, Mr. Philemon Ongri today has produced an office order dated 19 June 2025. Showing that the order of this court was inadvertently misinterpreted. So the office order shows compliance. Compliance, the office shows that salary of the respondent number 5
Rectification, my lord.
has been duly rectified, and this bursts at the relevant scale of level 9. So, as the matter has been settled, contempt, nothing remains contempt, the same is closed and disposed of.
Your Lordship.
Deeply.
Highly obliged, Your Lordship.
Item number 10.
Please, Your Lordships. Your Lordships, I'm praying for 2 more weeks' time, Your Lordship, to file my rejoinder.
You counted 3 weeks' time last time, so that you won't have to come and ask for more time.
Your Lordship, I have to make 2 rejoinders, Your Lordship. Separate rejoinders, Your Lordship, and that's why, Your Lordship. Lordship, the contention of the state is different, the contention of the union is different, Your Lordship.
3 weeks' time. Usually court doesn't give 3 weeks' time. We give 1 week's time now.
Oh, Your Lordship.
Yes. And yes, wait for the 2 weeks' time granted. File them. Yes. Expected the next day rejoinder should be on board.
Lordship.
But you listen for hearing.
Your Lordship, rejoinder for
11.
Your Lordship.
May I please hold? The state has to file affidavit, my lord.
Your Lordship, I'm praying for some time, Your Lordship.
Where's the inquiry report?
Your Lordship, Ms. Z.E.
Last time was submitted that is already completed.
We'll bring that on
Concluded,
record,
and
Your
you
Lordship,
just
by
bring
way of
this
an
aspect
affidavit.
on record.
We'll bring that on record by way of an affidavit. Ms. Z.E. Nonconry is conducting this matter. She's currently not available, Your Lordship.
So post it on tomorrow. Yes,
Your convenient.
MS Ailungma, who is present on behalf of MS Z.E. Nonconry GA, prays that the matter be adjourned for the day. Just after 1 week, yes.
Highly
Obliged, Lordship. 12.
Please, Lordship. This matter, they're supposed to file it affidavit. There's an order dated 09/6/2025.
Is that admission?
This admission regarding.
So what are you going to do?
Your Lordship.
How are you going to compensate the students?
No, Lordship, there is a
giving
regulation.
them,
May I take you to this? That there is a regulation on National Commission for Indian System. That there's a notification as a part of 16 February 2022. That's in view of this one. There is a particular section, Lordship. May I? There is kindly. Page 34, my lord, where in view of this one there is a and then
page
for 5, Lordship, for 5 it is. May I just page 34, page 34.
Para 5.
For para 5, just close one. I just read it. The designated authority by counseling of state and
For
union.
counselling?
For counseling of the state and union territory quota for admission to undergraduate program in or Ayurveda education institution in the state and union territories, including institutions established by the state government, university, trust, society, minority institution, corporation or company shall be respective state or union territory in accordance with the relevant rules and regulation of the concerned state or union territory as the case may be. Yeah, Lordship, this it says that as that admission should be given as per the rules and regulation concerned state Which means that there should be some rules and regulation framed by the state.
The
Now,
problem with this case is what, Mr. Sama? Before the counselling authority was established by the state of Meghalaya, you had gone ahead and admitted students. And then the mandate is that you cannot admit students without counselling. That's all. So what is the fear of the students who you have admitted on, what's that, quota seats? On your management quota seats? You've admitted students, they paid you fees, now they admit without counselling. What are you going to do? That is your problem.
Yes, Lordship, just let me complete. Let me take you to the Annexure 8 of my repetition, where it is connected to this rule, Lordship, page 53. Just have a look, Your Lordship.
Yes, we'll have a look. Why not?
Yes, Lordship. Because what I'm trying to make a statement, make a submission is this. Because of this one. 58. Yes, because this. Yes, page 53. There is a letter from the Counselor of Examination NCISM, Your Lordship. There is a last part. May I just read it, Your Lordship? To so and so the subject clarification regarding the direction admission by IA Ayurvedic Medical College USTM Meghalaya in the AY 2023 to 2024. Sir, Madam, it is come to our notice that AI Ayurvedic Medical College USTM Meghalaya admitted a student at institutional level in the academic year 2023-2024. However, as per the clause 1 of this
same thing.
No, Lordship, last part, Lordship, in the last worksheet, so and so, in that last one, it is requested to provide the clarification for the same at earliest, because this letter has never been responded
There's no question. It is requested for you to provide a clarification on how you admitted students into academic year 23-24 without counselling.
But,
it's not for them to clarify.
No, this is
means what? It's addressed to whom?
To the IS Mao Yang. This is the for IB. The state supposed to clarify on this matter.
They don't have authority. They brought affidavit, correct? They don't have authority. It was subsequently constituted. So you admitted students in a management quota without counselling. That means it's.
Your Lordship, if they are not filing the affidavit, let it be posted for hearing. I will.
What's there to hear? We can dispose it now only.
No, Your Lordship, because I have one. They want because
matter can be posed at any. Can you dispose at any stage?
Because
there's no counselling center. There's no counselling authority. No. You have admitted students. The requirement of this. What's it? National Commission in System Medicine. Whatever.
Yes, Lordship, it is there since.
You have not done it. So the
Lordship,
how many students you admitted?
36 students.
36. How will you compensate them?
No, Lordship, since
you paid them 5 lakhs each for the trouble you caused them.
Please, Lordship, today's
listed for
annual fees for filing the affidavit.
How much?
Total fees they are charging 30 lakh rupees per student, my lord, for 5
years.
5 years. 6 lakh is the fees.
So 5 lakhs already paid.
We'll have a detailed hearing, Lordship. I will. Yes, I will.
Pay them another 5 lakhs.
Lordship, I request for detailed hearing. I will try to satisfy with the court. I have some such since today is the fixed only for filing the affidavit, so I did not prepare for detailed hearing, Lordship.
Keep that in mind. You have a hopeless case to argue.
I'll try, Lordship.
Of course, you all try. Yes.
After 2 weeks.
You won't file affidavit? Oh, you already recorded that, yes. Place for hearing after 2 weeks.
Lordship, much obliged. Much obliged, Lordship.
13.
Students are jeopardized.
Lordship.
13.
I was all filed.
On behalf of respondent number 7, we are not filing any affidavit, my lord.
Lordship, on behalf of respondent number 3 and 4, I pray for 2 weeks time, Lord.
Already given last time. Yes, MST 3. You won't file. 7 won't file. 5 won't file. 7 won't file. You have 6 you won't file. Okay, that's only 3 and 4.
Yes.
1 and 2. 1 and 2 won't file.
Still awaiting us.
Who's supposed to give you instructions? I have to help you in every case. I've called them here for instructions. Like yesterday, unless our court gives order, he won't give you instructions also. Then, to further 2 weeks time as prayed. Your name?
R. Suchiang.
R. Suchiang.
Yes, Lordship.
for 3 and 4 allowed for affidavit stop. Similarly, the 2 weeks. Similarly, state Mr. Yusuf similarly, 2 weeks allowed for respondent 1 and 2 for affidavits.
14.
Please watch it.
5 to 8, you're not filed.
Lordship, I pray for some more time. Lordship is almost ready. I just need some more time.
Just 1 week's further time.
Lordship, hello, blood.
For affidavit by respondents 5 to 8.
15.
Hello, blood.
This matter can be posted for in their Friday, but there is an order on the 25/2025 for recording for calling of record, Your Lordship, but the record has not come. I think so.
Just Your Lordship, we have already filed the affidavit for this today. We have already filed the affidavit for today.
They said they have filed the affidavit during the course of the day. I think, but I have not received.
Where was the date? Yes, you want to file?
I will file a rejoinder to the affidavit filed by the private respondent as far as yes.
Mr. Petitioner plays for about 2 weeks' time for the rejoinder. With affidavit filed with the respondents 1, 2, 3. Yes, yes, up to 2 weeks.
Lordship.
Which of Lordship?
16.
May please, Lordship. Lordship, as per the order 19, we are directed to bring out the inquiry report, my lord. So I filed a case report, my lord, bringing the facts, and it appears from the inquiry report that his license has been cancelled. So, my lord, the petition is becoming infructuous, my lord.
Yes, my lord. I received instruction yesterday, my lord. The fair price shop license was cancelled after passing this order, my lord, on 24th June, my lord. And same was communicated and delivered to the petitioner, my lord, on 30 June, my lord.
No, were you heard before it was cancelled?
No, my lord. Same line, my lord. Which is why I pressed before on the motion stage, my lord, kindly some protection, my lord. My lord was not inclined to protect my right, my lord. No notice was issued, my lord.
Now this matter was moved on?
On 19, my lord.
Of June?
My lord.
Yes, cancellation order is dated?
On 24th, my lord. And delivered to the petitioner, my lord. Petitioner received, communicated
then you challenge it, you withdraw your...
My lord, yes, my lord.
Okay, Mr. S.K. Hassan submits that...
my lord, subject to one request, my lord.
Huh?
The respondent should submit, provide us the report. Both
Give
the
copy to the report. Yes, Mr. Hassan submits that...
For both. I've submitted, my lord, both the reports.
Okay.
Submits that after the petition has been filed before this court and moved on 19/6/2025, the license, fair price shop license,
yes, ma'am,
of the petitioner has been cancelled by an order dated 24th June 2024. He prays me allowed to assail the same and that the instant petition be closed with the liberty as prayed. Yes, the takedown as directed by the order dated 19/6/2025. Mr. G. Ndanja has produced the required report, whereupon it appears the license of the petitioner was cancelled. So, in these circumstances, the prayer of Mr. S.K. Hassan is allowed for withdrawal to assail the inquiry report and the cancellation.
Highly oppressed.
17.
For instance, goes in disposal. You want to take it back here?
My lord, yes, ma'am. Highly oppressed, ma'am.
Please, Lordship. So this was the matter where there is no regular managing committee in the school since 2022, and the government said, Lordship, that it is perhaps in the interest of things that a fresh meeting is called and a regular SMC be constituted. At present, there is a special SMC which I have challenged, saying that that has not been constituted properly. There is also a counterclaim of an ad hoc SMC which was approved and subsequently cancelled.
You have another petition.
In the next item.
In item
Why
18.
do you object last time that you haven't got a copy of the affidavit? What's an affidavit?
In the affidavit, they say that
What is the stand of the government?
government says that special managing committee was.
Oh yes, what is there? Nothing.
They only say that it's a special committee. Lordship, I'm only praying for a week's time, Lordship.
To do what?
Just to take instructions.
If even the government is saying, Lordship, that the special com was temporary at that point of time, and now, and it does not constitute a regular SMC.
That Council number 5 submits that he has since received a copy of the affidavit filed by the respondent before. He prays for 1 week's time to obtain instructions. This positively up to 1 week, yes.
After 1 week.
Obliged.
Much obliged, Lordship.
The second next
18
item
also is connected, Your Lordship.
Obliged.
Hearing, item 20.
Lordship, in this matter, I'm aggrieved with the order passed by the lower appellate court, setting aside the absolute interim injunction.
Lower appellate court?
Yes, Lordship.
This is, and before the trial court, what happened?
Lordship?
You are the appellant in the lower appellate court also?
I'm the plaintiff.
You're the
I'm not the appellant. I'm the respondent in the...
Respondent in the suit?
In the...
Defendant in the suit?
No, I'm the plaintiff in the
Plaintiff
suit.
in the suit?
Yes.
Then it was set in your favor?
Yes.
And then they went appeal, injunction?
Yes.
Okay, yes.
Your Lordship, as per the order dated 20th September 2024, last year, Lordship, of this Honorable Court, an interim order has been passed directing the parties to maintain status quo, which was done so till date. Your Lordship, if my respondents here, if they agree to maintain status quo, let the suit proceed, Your Lordship. Because since the year 2014, the suit, even the issues has not been framed, Your Lordship.
Since 2013?
14. The suit was instituted 14.
Is that correct? Issues are in frame also, Mr.
Yes,
Norma?
Lordship.
Not yet, Lordship.
Why?
Because of the appeal, because of...
That's a very sad state of affairs. It's pending for court of M. William.
Lordship.
District Council.
District Council.
Before the trial court. Lordship, if status quo be maintained, that is fair enough, I believe, and let the trial continue.
Yes.
Now, it means 11 years, the matters filed since 2013.
And the original plaintiff also expired while during the pendency of the appeal.
Both the respondents, Your Lordship, they are in possession as of now. If status quo is maintained.
Possession, we also claim possession.
No, they
the
are.
thing is that if you claim possession also, then out of status quo should not create confusion.
Yes,
you understand that? Okay, if it's well and good we say status quo, but then like, if you say status quo means I'm in possession, and they say status quo means they're in possession, then that creates a problem.
Status quo in the sense that nothing will change the character of the suit, Your Lordship. Nobody can touch that.
Lordship, as a matter of fact, Lordship, the respondents are in possession. So if status quo, since many years we have been in possession, if status quo is maintained, that is fair enough, Lordship, and let the trial proceed. In view of the order passing this in order,
yes.
Cool.
Five 724 order.
Yes. The operative part is 120, page 120.
Operative part is page 120.
120.
20.
Starts from last two line.
So at the time when you institute the suit, you're not possession of the land. That means, admittedly.
Lordship, all along I was in possession.
No, whatever it is.
Yes, Lord.
At it, when on the date you institute the suit, you're not in possession.
No, Lordship.
I am in possession.
You're not in possession.
Actually,
see, the order says that the person should have been admitted by none of the respondents, admitted parasel of the plain, which he found the land was fenced and boundary press constructed.
Because as per the...
So if you are not possession, how can injunction be granted in your favor?
I'm doing cultivation, plantation was carried out by me, Your Lordship, in the suit.
Well, it will kindly come at page 13.
Where did it appear from? I thought Mr. Jura was there.
I was called upon. Well, page 13, if Your Lordship kindly say page 13. 13, 1-3, my lord. The plaint. It's an admitted fact, my lord.
Well, then let's have a score, but let's have a score be maintained then. Let the suit
That's
proceed.
right.
How can the suit be pending for now for 15 years without issues being framed? That is.
My lord, what had happened is that after the petitioner herein had received the injunction order, then I had applied. I have filed an application for vacating the same. Thereafter, that injunction order was made absolute.
No, we understand.
My lord.
What do you think? Why? How can then why does the suit not proceed?
No, my lord. Then I had filed an appeal, my lord.
So because of the appeal, the suit was stayed.
The entire records were called for that during that period, my lord. So after that, this matter has come before Your Lordship. Well, there's no, in my respectful submission, my lord, this is a matter with regard to injunction, my lord.
So we'll close it. Let the status quo assumptively be maintained.
My lord, in as far as the possession is concerned, my lord, it's an admitted fact by the petitioner themselves, my lord, that they are not in possession.
It doesn't matter when a suit goes, but it might be restored to possession. You don't know. But that is, we ask for declaration in a suit.
Yes, yes. And suit has been filed.
Okay. There is CL deed. This property was yours, sold to Mr. Nongklau's client.
No.
Mr. Walang's client.
Mr.
Walang's client.
Mr. Wallenstein in turn sold
to us,
both of us.
To both of us.
And in turn sold it to two of you.
Yes,
So
Lordship.
it's already gone to
my lord.
two-fold.
Yes, Lord. One of the cause of action is 2011. The suit has been filed 2014. After 3 years, my lord.
Then you have those have to come by issues and evidence later on.
My lord.
In trial only.
Yes, sir. Take down. This appeal. This is the second appeal. Has been referred against judgment order dated 5/7/2024, passed in Business Civil Appeal number 1 of 2016 by the Judges Council Court. Stop. The brief facts are that the appellant, you were original plaintiff, as the original plaintiff, had instituted a suit being TS number 3014 before the Subordinate Council Court at Shillong against the respondents for declaration of right, title, interest and ownership over a plot of land located at
Tendring Village.
Tendring Village more particularly described in the plaint itself. Next paragraph, it appears that the plaintiff, when was injunction order dated?
The injunction.
An interim injunction was first passed on 25
It appears
to
that
2000.
thereafter, interim injunction was granted in favor of the appellant plaintiff.
25 to 2014.
25
to 2000. February 2014.
And the same was made absolute.
Absolute on.
No, my lord, after that, I had filed an application for vacating the same, my lord.
Then when appeal?
No, after that, the injunction order was made absolute. After that, I had preferred an appeal.
It was absolute. It was made absolute.
Subsequently made absolute on
3rd October 2016.
3rd October 2016. Appeal was thereafter preferred by the respondent number 1.
Yes.
Number 1. Then before the court of the judge, the successful court, who then passed the impugned order.
5th July 2020.
Setting aside the order injunction passed by the subordinate district council court. This court, this appeal on comment be considered of this court. What's the order you said?
20th September.
This court. September 2024.
24.
This court then by order dated 29/2024 passed in this case Nata square bracket MA S small bracket then S sampai nimo. This court by order 29/20/2009/24 passed so and so while admitting the appeal for hearing and directed that status quo be maintained with regard to the suit land, today when the matter has been called out for hearing, the learned counsels for the parties jointly have submitted that as a title suit has been pending for a long period of time without any progress, they are agreeable if the parties agreeable if status quo has been maintained and the suit be directed to be proceeded expeditiously. Stop. In consideration of paragraph of the submissions of the counsel for the parties, is hereby directed that status quo shall be maintained with regard to the suit property till the disposal of the title suit. Stop. It's also directed that the suit should be proceeded with most expeditiously, considering that it has been instituted as far back as in 2014. Yes.
Same order may be passed in another case.
3, 4.
3 and 4.
Yes.
Item number 21.
Same order.
Same order.
What happened is
The difference is on.
2 appeals was filed.
2 appeals filed by whom?
1 appeal was filed by me.
The other one was filed by me, Lordship.
Before where?
Same court.
Okay, yes. Same order means.
Yes,
Same order may be passed.
Yes, matter appeal only stands on the terms as agreed upon above. The appeal stands disposed of.
The only difference is the different cases are there, Lordship.
Yes,
2 items.
Different numbers.
Yes.
25.
Highly obliged.
Highly obliged.
Please, Your Lordship, I beg to pray to adjourn for this matter because my learned senior, he's not ready for this matter and he's also occupied in other courts.
He's not ready, he's occupied. Make up your mind.
He's not ready, Your Lordship.
He's not ready. Very good.
I pray for 2 weeks, Your Lordship.
Yes. Council will pray that the matter be up to 2 weeks as having council is not ready with the matter. Not approved by council for the petitioner list of 2 weeks. Yes. Good. Yes.
Much obliged, Your Lordship.